Connected read petition is listed before your load.
Amount of work. Please mute yourself for a minute. Let the mention be over. Yes.
For listing of one I tomorrow, the connected read petition is listed before this on report is item number 11 tomorrow. Of like.
Suppose with the consent of the address, I beg to mention I did not 12 lost. In this case, I supposed to file an additional affidavit. So can I done it for a week?
It can be as then on.
Okay, no. Item 12. You are for? I'm for respondent.
I'm for the.
There are some additional documents is required to file additional affidavit. No, as per last order, there are some question was raised. There should be some salience to some decision.
I file a read petition, madam. I also mentioned
You have filed up subsequent to that order.
the filing number is also.
So we'll say, okay. Just wait for some time. We'll pass the order.
Your Honor, may permit me to mention item numbers 19, 20, and 21, the consent of the other side. A transfer petition is pending before the Honorable Supreme Court with regard to all these three writ petitions. Seeking adjournment for some time till that transfer petitions can be decided.
These are being decided, isn't it?
It is being decided, Your Honor. Actually, the
actual issue is
going to be
being decided. It's being heard continuously. 9 judges bench,
absolutely.
isn't it?
It's been tagged with that matter, actually, the transfer petition.
So otherwise you'll have to adjourn,
Exactly.
isn't it?
That's correct.
It is submitted that issue which is involved in the present batch of writ petitions are being considered by the Honorable Apex Court, in the case of
Your Honor, it is in civil appeals number 4056.
in the case of in civil appeal
Number 4056
number 4056
to 4064 of 1999.
slash 2064
No, 406
4064
of 1999.
of 1999.
Nine.
In view of that, this matter stands adjourned and be listed after a determination is made in the aforesaid civil appeals. Like this.
May I please the lordship, with the consent of the other side, I beg to mention item number 11 of the daily lordship. In this matter, lordship, Mr. T.J. Mohan, sir, senior advocate, is appearing in this case. He is out
Item
of
11.
station, lordship.
Item 11.
Lordship. He is out of station today, lordship.
Okay.
Obliged, sir.
On the prayer of petitioner stands adjourned, will listed after 2 weeks.
Obliged, lordship.
May I please alert. Item number 1 is become effective.
This submitted. Item number 1 is 1036/2021 steps.
Yes.
It is submitted by the learned counsel for the petitioner that this matter has become infructuous. Accordingly, the petition stands closed being infructuous.
All right.
Lordship, regard to item number 47 to 48, Lordship, we are proposing to file an additional affidavit there, Your Lordship. That may be called for, Lordship, and if it's not inconvenient for the court, it the matter be taken up at 12 of June.
Why?
There is some urgency, Lordship, because there is no interim order in that case. Lordship, the Buffalo flights are still conducting, Lordship. Buffalo flights, Lordship,
Okay.
are still conducting. Because there is no
Item number
47 and 48.
heaven will not fall. It is being continued for years.
No, Lordship, in the SOP, Lordship, there is a specified time, Lordship, has been mentioned.
Oh, cannot say at 12. This is not a that urgency. Somebody's house is being evicted, thrown out, will not take up. This is not that. We'll take up. No problem on that.
The additional affidavit may be called.
Oh, let that be called.
Much obliged.
May I have your lordship indulgence
Hmm.
to mention item number 5. In fact, this item has become infractuous in view of the order dated 2/11/23 passed in WPC 644.
Become infractuous. Okay, being close, okay.
Could you, lordship, say that in view
Okay,
of-
it is submitted by the Mr. Buragoy Learned Senior Counsel, SC Buragoy Learned Senior Counsel, that this
You will be
repetition
ordered
has become infractuous in view of the determination made by this by determination made in
in
WPC
WPC 644
644
public 2023
2023.
dated 2/11
In view of the order passed in order dated
2/11/2023
to 28th of November 2024,
second into November.
2nd of November 2023, passed in
WPC 63320.
2020. In
Obliged.
view of such submission, this petition stands closed, being infractious. Yes, please. Also call it, he is here, let us see. No, very true. PC two. Yes, Mehdi.
Hello, this is there's containment the document and the document filed by the Union of India. Present this order was passed.
What order was passed in the writ petition?
This matter I'm facing it for it.
Huh?
I'm facing it for it.
How much cost this time?
And that is only this, we present filed for expending cost matter. This is our prayer matter. Only this.
We will consider the this review after your compliance of the
Yes,
order passed in the writ petition, second writ petition.
yes.
When the writ petition is there.
My lord, on 8th of this month, my lord, on the. right.
So we are taking up immediately after it.
Only this, only one objection is there, yes, so far the flip, which was, the cost was imposed by the Honorable Court,
Hmm.
then there's another alternative remedy was there,
Hmm.
and so for paragraph 7 of this, order, my lord,
Hmm.
they, from it starts, my lord, the paragraph 5, my lord. 5 page, my lord, 5. The inaction part of the petitioner, it did not stop here. The petitioner therefore filed.
Which order?
My lord, passed in at the place before the petitioner. WPC number 127/2023, my lord.
The recent order, yes.
Yes. Passed
Then?
honorable justice.
Hmm.
My lord, so far, my lord, this paragraph, my lord, 7, 8, my lord.
Hmm.
8, my lord, at this stage, court finds the relevant note that section 12 of the Act 1965,
Hmm.
which permit the person aggrieved by an award to seek reference from the collector or a decision of the court. This court finds that it relevant to take note on subsection 2 of 12 of Act 1965, which stipulated and the provision of land acquisition 94 maintenance mandate apply in respect any reference made in court under subsection 1 of section 12 of the Act. B, that as the court also find the pertinent to note that section 25 of land acquisition, which stipulates the reference court cannot reduce the compensation which have been awarded by the collectors. Under such, it is the opinion of the court.
We understand.
Yeah. So this is my position.
This is the
I-
position.
yes,
Therefore, you are fighting litigations after
Yes.
litigation.
only they are in division.
We said that in the earlier order. Why said taking note of this?
Yes, my lord.
Even if you prefer an appeal, what is, we have not recorded that, but this order has clarified that position.
In division, the judgment was passed, my lord. If there is discriminancy, my lord, and arbitrariness, my lord, then now we can approach that. Well,
You can approach whom?
before my lord, as per challenging the award, my lord.
Hmm.
Award, my lord. Our intention was, my lord, is
We do not know. Now, what is the ground of review? Tell us.
Town matter is only this we because we filed section 12 this application before the revenue authority matter. They as per this honorable court, this alternative remedy was there. Accordingly, our petition was dismissed, my lord, by this honorable court, my lord. So we approached this because of the wrong, we approached it in wrong forum in earlier, my lord. So we approached subsequently same also rejected the
So section 12 also rejected.
section 12, my lord, is the rejection, my lord, was, my lord, I have also placed before the honorable court, my lord. There is no such reasoning, my lord. There is no such.
No, that is not our subject
Yes,
matter. You have your remedy
yes,
on there.
Yes, yes. So thereafter we approached another requisition before the honorable court. This last order was passed on I placed this one. It was fixed on 8, my lord. So this is the case, my lord. Only this review petition from filed for expanding the cost element. So this is our prayer, is the unlimited prayer.
Cost, okay, fine. But what about the,
My lord, we now on 8 will already.
your Union of India is concerned with cost of 50,000.
No, my lord, no, my lord.
Huh?
Big-
And how many years you have not paid the land acquisition compensation and how many litigations? How much money you have spent on lawyers? Give us details.
that is-
File an affidavit, give us how much cost this Union of India has spent for this litigation of non-paying compensation to a land acquired,
that
and give an affidavit, then we'll only consider. Give an affidavit, how much cost you have spent for this litigation.
My lord, we have submitted this on wrong forum, my lord. This matter was initially.
Whatsoever, we do not
My lord,
know.
my lord,
What was the first award was passed when?
It was award was passed in 2012.
2012.
Yes.
Then what happened?
My lord, these ballots.
Then you have to, then you preferred a writ
No, my
petition.
lord, we have not, my.
Then
Order was, my lord, the state government will, my lord, pay. Thereafter, it was reimbursed.
no, whatsoever. Then what?
And-
Who started this litigation? The other side started this litigation. Then writ petition was allowed.
Written allowed, my lord.
You prefer, you went to division bench.
Review, my lord.
Review.
My lord.
Review gone. Then to division bench.
Division, my lord.
Division bench gone.
Yes.
Then again division bench said you approach the, have the alternative remedy, you go.
Yes.
Then you, instead of filing a 12, you come to the, again you file a writ petition against the.
Lordship, they went to Supreme Court also.
Oh, you went to Supreme Court, that dismissed.
Did not-
Then you come back to this court challenging the award in writ petition. That was dismissed with cost of 50,000.
Yes.
Then you, what did you do thereafter?
My lord, is as because this it is not dismissed, my lord. On the ground it is not maintainable. There is the alternate provision, my lord. As we approached earlier in wrong forum, my lord. They in compliance of as per provision of section 12, my lord, of the Nagaland Act, my lord. We filed a petition before
That was dismissed.
that was rejected, my lord. Rejected. My lord.
Then what happened?
Then, my lord, this present
Then you preferred again a writ petition.
present represent, my lord, before which order was passed.
Writ petition. Now writ petition's order has been passed that by 8 you
Yes.
pay the amount.
Yes.
Now we have become wise and review.
Yes.
Now we are dismissing this right now. With how much cost, tell us.
This one is only for the expanding the cost.
That's why you are imposing much more cost for filing a review. What is the ground of review? Tell us.
This only this three ground is there, my lord. Only this limited ground, my lord.
You have two options. Make a prayer of adjournment
Yes, I will.
till 8. What you do on 8, come back,
Yes,
and then we'll see.
yes, on after 8.
This is not the way.
I know.
This is not the way Union of India should
I know,
litigate.
my lord.
This is not the way. On the prayer of Learned Council for the Union of India, matter stands adjourned.
Yes.
and we listed on
11.
11.
Not yet.
Lordship, on,
Leave it, we don't have any
Yes,
problem.
yes, and
Lordship, is it listed on 11th, Lordship?
No, just
Next
a
day.
minute. As per his,
my lord, on my lord, 20 or 20.
28th of March, 20.
20, no? 20.
File.
Lordship. Lordship. Oblige me, Lord.
Item 14.
Oh.
Be ready to, you have obtained instruction from your client that how much you have spent for this litigation from starting from the writ petition till now.
It is there,
We'll ask you to file an affidavit. Then we'll pass an order. What kind of litigation should be pursued by Union of India? What should be the litigation policy?
Oblige me. Oblige me.
Yes,
439 application.
that dispose of matter is here. This is first, we have passed some order, isn't it?
On last occasion, your lordship.
Okay. What is the,
Yeah, my main ground was that.
My lord, here, my lord, similar case, my lord, allowed, because of that now it is listing. Now, one thing is that, my lord, at that time, no, witness was examined.
examine. Now, what is the
Now,
present position?
Present position, last order is, I have tag mark 19/12/23, 2 witness examined, but the evidence are not available in the, my lord, LCM, my lord. But, it is fixed, again on 2/1/24, already gone for further evidence. So, my lord,
Okay,
may some person already-
just a minute. We can obtain through online. These are all online. What happened after?
no, online status may come, but the evidence are, matlab, perhaps matlab, after that, 2/1/24 was the matlab, last order. 2/1/24, maybe matlab,
We were not granted bail only on the delay ground. Lordship may kindly-
No, Mr. Ahmed. You ought to have obtained a copy, scan copy. These are the 2 orders. Thereafter, this is the evidence. Then we'll have to call it from the registry.
because matlab, at that time,
Okay.
no one examined. Matlab, at that time.
Ultimately, you cannot forget the decision, commercial quantity and DPS. We cannot pass a similar order like this. We'll have to see, we'll have to pass a reasoned order. Heard Mr. Ahmed and Mr. Swenso. The scan copy call for has been received. However, for proper adjudication of the bail application, this court will require the scan copies of orders passed in orders dated 2/1/2024 and 12/1/2024 and any order passed thereafter till date along with copies of the
Deposition.
depositions, if any,
Of the PDF.
of deposition deposition of prosecution witnesses as may be available. Full stop. List this matter on accordingly call for the scan copies of the aforesaid documents. List this matter on it.
কথা নাই, raised-
Can you see the dates? What is the next date fixed in here? What is the next date?
60.
Huh?
60 month.
6/3 means
60, 24.
March.
60.
matlab, today is 4.
today is 4.
On,
Order tenaka likha any deposition so and so which might be available
12 month,
till the sending of scan copies. I'll just correct this order. List this method 12.
12.
Okay. Just need to hurry for you. Only these copies only. They can mail it also. Mail kuri to dia. Okay.
Abla.
Review file to আনেনি G2 হেরি আমি যেটু ললো ভিসির ফাইল খোলা ছিল ঠিক আছে এটা রাখে তো Hmm? Hmm.
That's it, the fee service was to be paid,
Huh,
but we have done it like we haven't filed the affidavit,
why?
so sometime maybe given, when it was done only on last Saturday.
And you are enjoying a stay order.
It was, let's say, status quo kind of thing, it's not, and like this party was actually added later on. So we'll
Okay,
file an
Mr. Kolita, learned counsel for the petitioner submits that, sir, here office note says you have not taken.
No, we have taken on last Saturday, Lordship, so we'll have to file an affidavit to that effect. So we'll file an affidavit
28 to 2024. So you have taken steps when?
last Saturday. Last Saturday. Second of,
2nd of March, you have taken steps.
we have served the copy, so we'll have to file an affidavit to that
You have
effect.
served a copy on
Yes.
petitions. Okay. Mr. A. Kolita, learned counsel for the petitioner submits that steps through the steam mode has been taken and an affidavit is being filed.
Affidavit will be filed.
Is being filed when?
Within a
During
week,
the course of the day.
Within a week.
What?
The
Mr.
client,
Kolita,
let's say client stays in.
taken steps? And affidavit will be filed within a period of 5 days from today. In view of that, matters to adjourn and be listed after a week.
Oblige. Orders, item 41.
কিবা বনাইছিলা? Okay, okay.
May I please?
Yes.
In this case, your lordships, order was passed on 2/6/2021 in WPC number 5753/2021, your lordship. And in order, lordship directed the respondent number 1 to consider the.
No, you know, name of D. Saikia, R. Borpujari and Bodoleswan. Huh? Was this নাম দেখাছেন রেসপন্ডেন্ট? Yes, yes. Where is the order?
Order at page 8, your lordship, annex I. Operative part at page 10, your.
And for respondent number 1, my lord. DD party, my lord.
Huh?
And for respondent number 1, my lord.
There is sole respondent, no.
Yes, my lord.
Huh?
Yes.
Huh.
We have complied, my lord. We have written to the. Deputy
You have
Commissioner.
complied what?
Yes. We have considered the online budget numbers to the deputy commissioner, my lord.
No, you are supposed to give us, you are supposed,
Release the budget allotment, my lord. To
budget allotment to whom?
to deputy commissioner, my lord.
You have been, this commissioner relief and rehabilitation
Yes, my lord.
was asked to dispose of his representation. Of the petitioner, release of ex gratia in terms of notification on and on or before so and so.
Yes.
Now, money you have sanctioned only in against this person
Yes.
or as a whole budget sent to the deputy.
No, only this person, my lord.
So,
Yes.
yes,
Lordship.
any instruction from your client?
Yes, lordship. Yesterday I talked with my client. He has not received them.
Okay. this court, by its order dated 2/6/2022, passed in WPC 5753/2021, directed the sole respondent, that is the Commissioner and Secretary to the Government of Assam, Revenue within bracket Relief and Rehabilitation bracket close and Disaster Management Department to dispose of the representation of the petitioner relating to release of ex gratia grant in terms of government notification dated 15/11/2014. Full stop. The learned counsel for the sole respondent has produced a sanction order which shows that an amount of rupees 2 lakh as being ex gratia grant to the in the name of the petitioner has been made. And the sanction order further reflects that Deputy Commissioner of the concerned district is to release the said amount. Isn't it?
Yes, ma'am.
In that view of the matter, the respondent, the sanction order has been issued not by yes. However, the learned counsel for the petitioner submits that he has specific instruction that the though amount has been sanctioned, no money has been disbursed to the petitioner. That being the position, yes, government, Deputy Commissioner, have an instruction at 2.
Sure.
Give a copy. You keep it to Rakitra, Duta Bajati. So give him a copy.
Sure.
Otherwise, may
Ah.
close the counter.
We'll close.
the-
We'll ascertain, give a copy to him.
My lord.
Because this is being done by the Deputy Commissioner. You have it whether money, why money is not transferred.
Yes, my lord.
Okay,
Take
at 2.
that
এখানে রাখি একটু দিবা, পিছিয়ে লাগবে।
one.
Yes,
Please, Your Lordship. Your Lordship, kindly, it is the order passed by the laws imam 17/1/2023, my lord. 17/11/2023, my lord. As per that order,
respondent number 5 service is complete.
complete.
Okay,
Yes, sir.
so service is complete.
Yes, sir.
Okay,
And
this
they
matter
find
is
the-
ready as regards service. However,
They find the affidavit of-
and service, the respondent number 4 has also filed an affidavit in opposition. Do you want to respond or no?
I thought- Huh? That is correct.
No. Accordingly, list this matter in the admission column. Okay,
Yes, sir.
any interim order? No.
No, my lord.
Okay. Uh,
Yes.
when? What is the issue here?
It is simple, my lord. Petitioner was thought to be evicted from their place from the my lord, residential place. And what happened, my lord? In this case, my lord, this earlier we approached before this honorable court, my lord. The honorable court has directed to dispose our representation. There is an order, my lord.
Mm.
They filed the affidavit,
Mm.
but not a single. And they have mentioned the reason.
Okay, give a date.
We also filed the IPR also, no reason order has been given.
Okay. 28. Next case. কিমানটা আছে আপোনাৰ admission? This matter is ready as regards service. Accordingly, list in the this matter is ready as regards service. Accordingly, list this matter in the admission column after 4 weeks. Hey, ready. Some of the part to ladies.
Matter pertains to my lord some reference cases method.
Some reference
Yes,
cases.
my lord.
What some
The
reference? Case?
petitioners, my lord, their number of petitioners, my lord,
Ah,
who received the compensation in respect of their appeared grants.
ah.
Thereafter, they made application.
Now
before the
tell us,
petition.
where is the order?
Order is at page, my lord. Page 20, my lord. 20 operative part, my lord, that started from page 25.
Yes, Goswami.
To
Our prayer,
Office note dated 1/3/2024 reflects that notice issued to the sole respondent has been received back unserved without any postal remark on it. Full stop. The petitioner is permitted to take fresh steps. This court, by its order dated
22/3/2022, my
by its order dated 22/3/2022, passed in WPC 6602/2018, directed the Deputy Commissioner, Kamrup Metro Rural,
Kamrup Metro, my
Deputy Commissioner Kamrup Metro, to refer the dispute as regard dispute as regards compensation payable to the petitioners within 15 days from date of receipt of the order. It was further directed that the applications filed by the petitioner before the Deputy Commissioner should be treated as an application under section 12 within bracket 1 of the Assam Land within bracket Requisition and Acquisition Act 1964. Full stop. Full stop. The petitioner, according to the petitioner, they have served copy of the order upon the Deputy Commissioner. Where?
date, my lord, 9/5/2023.
Where is that?
I have the receipt.
Where is the statement in the contempt petition?
Not there.
Huh?
My lord, we have served the.
No, we
contempt-
understand that. Where is that statement? Where is that document in the contempt petition?
It's not there. My lord, after listing this contempt, my lord, we have taken step, my lord, upon the deputy.
No, we are not saying that. There was a direction from this court
Yes.
directing you to serve, isn't it?
Yes.
How the Deputy Commissioner will know? Okay.
Application, my lord,
Page steps.
18/5/2022,
Page,
page
page.
28.
Hmm.
Page 20.
Okay, on 18/5/2022. Simple order.
Look.
Their application is to be referred to a district judge.
Look.
District judge will take a call.
Look.
For that, if you need so much of time, in that view of the Mr. Goswami and NG
And
Goswami, learned State Council is requested to obtain instruction regarding status of compliance of the aforesaid order. Full stop. List this matter on. Give a date. Next week.
Okay.
14th of March 2024. Full stop. The learned counsel for the petitioner shall furnish a copy of the contempt petition to Mr. Goswami along with a order passed today.
Fine.
Full stop. Registry to list this matter showing name of Mr. Goswami in the cause list.
Obliged.
Give a copy and the order.
Look.
Simple.
Look.
You just say refer it under 12(1) to the
district judge.
the district judge.
Look.
That's all.
Obliged.
May I please lordship, my senior counsel is not,
Huh?
my senior counsel is not available. Some
Who is your
personal-
senior counsel?
M. Burman.
M
Meghali Burman.
appearing for?
Appearing for respondent number 1.
Who is for respondent number 2?
Lordship, I am appearing for respondent, but
Okay. You want time or what?
yes,
To
Lordship.
file affidavit?
Yes, sir.
Lordship, kindly maybe Wednesday.
Huh?
Time. Lordship, maybe Wednesday.
Huh?
Kindly time
Kindly time what?
6 March, 6th of March.
You have been given a huge task to do, to consider his representation and disposal. Who is for respondent number 3? Respondent number 3. None appears for the petitioner on call. The respondent number, runner counsel for the respondent number 1 and 2, press for and is granted 2 weeks time to file a affidavit of opposition. List accordingly.
My lord, amount has been already paid to the deputy commissioner on 26th of February. So this is the instruction I have received, my lord, this may be kept as a record.
What is this IA?
I is for impeachment proceeding. The DC has not.
Where is the order? Main case. But where is the order?
That your lordship will find in the contempt petition, page, relevant portion is page 16.
Page 16.
Yes. Only serial number 4 was left out. Now that has been done.
None appears for the petitioner on call. This court, under its order dated order dated 3/1/2019. Passed in WPC 2718/2009, issued certain directions as regards payment of compensation, payment of unpaid compensation in respect of land acquired, land belonging to the institution acquired by the petitioner. Yes,
Yes, Lordship, they have complied.
complied. Okay.
Only to the extent of payment, depositing the payment
Mm.
to the DC.
Huh.
By the central, defense.
Mm.
And in the meantime, your lordship,
Mm.
commissioner has awarded, made award, and we directed us to submit the documents, relevant documents, and accordingly we today submit the documents.
I will get it.
District Commissioner has issued a notice to them to
Huh.
come and collect the
Huh.
amount with some documents.
Contempt petition may be closed.
Okay.
We'll close.
Till disposal, till disbursement of the amount, the lordship may kindly pending the matter.
Why should we?
Lordship already
Payment is made, this money cannot go in
Anywhere. else.
anywhere.
Yeah.
Land acquisition compensation,
Yes,
head
yes,
is
of-
land acquisition
Land acquisition.
compensation, it is in your name.
Yes.
Okay, don't know. Come back once again, if necessary, they will pay it. Payment, it is submitted at the bar that the order is being complied with, full stop. The learned counsel for the petitioner, however, submits that though money has been sanctioned and transferred to the account of the deputy commissioner, and the deputy commissioner has asked the petitioners to appear before the deputy commissioner with certain documents on
No,
so,
date have been mentioned.
ask the,
However, we have submitted today.
okay,
On 29th too, notice has been issued to
Issued.
them to collect,
on
come and collect.
on
to come
29th.
submit.
On 29th of February,
On 29th of February,
notice has been issued.
notice has been issued, notice has been issued to the petitioners
Okay.
for collection of such money.
Yeah. They
In
will-
that
they will
view of
ask
the
the
matter,
My lord, my PR may be recorded there. We have made a PR before you to close the petition, since we have paid. I'm wide aware. Correspondent number 1 and 2.
generally we pass a order, this or the order that so and so is complied with, in, it's closed. It's closed. At so and so, so and so, so and so. It is submitted at the bar that the order that it's so and so, passed in so and so is, has been complied with and complied with. The petitioner submits that though money has been sanctioned, he is, the deputy commissioner is asked him to appear before the deputy commissioner with certain documents. Full stop. In view of this aforesaid, the contempt petition stands closed.
Obliged.
Lovely.
What is this IA in view of the order passed in the
I was the implement of the.
Not-
Not necessary. my lord.
contempt petition, IA stands closed. Yes, Mr. Das.
No, we filed an IA.
Hmm.
We filed an additional affidavit bringing notice to the court, I think it has not come up before this court.
Item
This is-
46, Sonapur Tea Company.
No, 47.
Huh?
47, 48.
Sonapur is over, na?
47, 48.
Okay.
My lord, they are
Okay, let it come. There is a mention.
violating, as on date, they are violating the orders.
Hmm.
How they can issue, how the other district can hold this fight? SOP, your lordship can kindly see the SOP.
Okay, let the IA come, let the IA come.
I am not, we file an additional affidavit,
Okay, let that come,
additional affidavit.
let that come. But you want to do it at 12.
No, it's not, I make sense.
You want to do it at 12, we'll wait till 12.
If it is not inconvenient.
No, he said not inconvenient.
Wait for
But
all the affidavit.
ultimately, I told my learned friend that we have to file an IA. We have to file an IA. For restraining, you have to file an IA.
Of
He's
course.
only bringing notice to the court about the additional affidavit. That's only we have brought.
So what to do today?
No, that's why I'm saying, we ultimately, we have to.
You file an IA in the meantime,
We
we'll
will file an
consider maybe tomorrow, day after, if you say that
No, day after
urgency.
My learned friend comes from Delhi, my learned friend. Only that's why if he is there. but- Let the additional affidavit come.
Okay,
Then
we'll
your
see,
lordship
we'll
will-
see. We are not powerless to pass an interim order.
No, yes. Yes.
We are in a writ court.
Yes. Writ
Okay,
court
we'll
is-
see, we'll see,
yes.
but in a deserving case.
Yes,
only.
yes.
Yes. Item?
Okay, in respect of respondent 5 Mallards,
Hmm.
we have taken steps from justice service Mallard and accordingly I have filed affidavit 22.
An affidavit has been filed as regards completion of justice service upon respondent number 5. Full stop. Peruse the statement made at paragraph 2. Full stop. Service is accepted as the notice has duly been served upon respondent number 5. List this matter. Service is complete.
Yes, ma'am.
Service is complete. List this matter in the admission column. At least after 2 weeks. The interim order pass earlier shall continue till then.
Apply.
In the meantime, parties may exchange their pleadings. Two কি হল? Two? One to infraction হয়েছিল? Oh no, okay. Two হয়ে গেছে, হয়ে গেছে. Item?
Item 3.
Lordship had required access. Although the lordship would like to have the CRPF act.
Hmm.
CRPF act.
Mr. Majumdar, if you are not otherwise any problem,
No.
we want to take up this matter after completion of the admission matter.
Done. No difficult,
Okay,
no difficult.
because let the other matters be finished, we'll concentrate on this after the admission matters are over. Because we have completed the order, matters. Now we will have around 39 matters. I think we'll be able in the second. I think so. Okay.
Item 4.
Lordship,
Hmm.
we have on my senior Mr. M. R. Kundakar,
Huh?
kindly pass for time. Kindly pass for time.
Time being, why?
My senior, no,
Okay.
Item 6 and 7.
Hmm.
this one previous occasion on 19th,
Hmm.
last one was given to, I'll reply affidavit.
Hmm.
And we filed on 2nd of March, it is not taken.
My lord, that may not be required, my lord, because
Lord.
we have raised the issue of maintainability of the repetition, my lord. That preliminary issue has to be decided first. This is not maintainable at all. Because
Tell us first, they went to the district judge.
A district judge, under section 9 of the.
That has also been dismissed.
Dismissed.
Then why not, then what will be their remedy?
My lord, before this honorable court by way of an application under 227,
Hmm.
but the thing is different, my lord. The petitioner herein is totally alien to the cause of action and the proceeding. The petition.
Who are they?
It's a society, my lord. No eviction notice was issued to them. These eviction notices were issued to 75 individual persons.
Huh.
My lord, separate eviction cases were registered,
Hmm.
and then all these notices were not under challenge before the honorable district judge, my lord. And even before this honorable court, these persons are not parties, my lord.
Where is the order of the district judge?
Lordship, order of the district judge,
Hmm.
Lordship. Page number 308, Lordship.
All these
Page number?
aspects,
30?
308, Lordship.
these aspects have been discussed, my lord. Paragraph 7.
Who is this Bimal Sil?
Bimal Sil is the president of the committee, Lordship, representing the interest of the. Lordship, this only the main reason why this was dismissed, Lordship, it is reflected that there are no documents on record, no even a single document or notice was filed. Whereas we have filed, that is on record. There is order also from the court.
Paragraph 7, my lord,
That is
page
left out.
310 would give some indication. Then paragraph 11, 12,
Lordship, in our reply WF, we have all mentioned, clarified everything. That may come to record. Lordship, anytime, Lordship, you fix, Lordship,
Yes.
I am ready, Lordship, but reply has to be come to record.
Reply file?
Yes, Lordship.
When?
Saturday,
Second.
last Saturday, my lord.
Second,
Okay, we'll call it.
Lordship, before. And they have filed one additional affidavit copy. I could not receive, so in additional affidavit, could not file.
My lord, without serving
That is
copy, I could not have served the.
In the last date also asked for my learned.
No, not at all, my lord. Lordship may see, kindly see the records whether I have served copy or not, my lord. Without serving copy, I could not have filed the additional affidavit. These are just dilatory tactics, my lord. For the last 7 years, my lord, the development projects have been stalled, my lord. There are 3 sanctioned projects against the land, my lord.
What were your grounds?
Lordship, my ground is on.
Tell us. What are your grounds?
Lordship. Lordship, before that I come to the fact, Lordship.
No, we understand. Facts is simple without going through the file.
Lord.
The railway says,
Yes.
whether Kalibari or the others,
Lordship.
you are in unauthorized occupation of railway land.
Lord.
This is their allegation.
Lord.
Okay? Accordingly, they issue a notice.
Lord.
Now, what is your defense?
My defense is, Lordship, we challenge the notice. It's not valid.
Why?
Section 4, because notice was not filled in completion. It was, notice should be filled in completion. Premises should be described completely, Lordship. In that notice, though the boundary tag column was there, but no specific boundary tag mentioned.
Now, have you raised this issue before
Lord.
the estate officer?
Yes, no, Lordship, we raised this issue before the appellate authority.
How, no, who went to the estate officer?
Lordship, that's one I am telling, Lordship. First, the impugn order was, notice was issued,
Hmm.
and subsequent eviction order.
Hmm.
Then that order was issued lately to us after the statutorily mandatory period of 12 days.
Hmm.
So that's why we have no alternative.
Any notice issued in the name of Kalibari?
Not Taliban, Lordship, in
So,
Every
so if there is no notice on the Kalibari, how can we determine about the Kalibari?
not Kalibari, it's Sarvajanik Kalibari committee representing this.
So
land.
anything has been, any notice has been issued to this society?
Yes, Lordship, all the members of the site and represented by the president. That's why we came to High Court and Honorable High Court. It
Hmm.
was their submission that you go, they may avail the alternative remedy of
Hmm.
appeal
Hmm.
before the district.
Hmm.
That's why we went there, Lordship. So, and we filed appropriate appeal there. In that
When
appeal,
can you be ready for decision of this case? Day after tomorrow?
Lordship,
Day after tomorrow. It is stated that an additional,
Long back, my
Lordship,
additional.
additional affidavit, we have only 1 day's time you file a reply. There.
Again, this will delay. my lord.
Only 1-2 days, Lordship. 2 days, Lordship, I will file.
see, we will determine on the basis of, suppose forget about this maintainability for the time being. even if we enter into the merit, we will decide on the basis of the judgment. We are not here to decide the facts.
Yes, Lord.
What is the additional affidavit, reply affidavit? What is the meaning of this? In a proceeding where an adjudicating authority, statutory adjudicating authority has decided, we'll look into that things only. That's all.
Lordship,
Record isn't it?
one, Lordship, apparently 7/2/2015 order, Lordship, from that court, 7/2, kindly, Lordship, see.
Records are
Yes,
there.
183, Lord.
Records are there. We'll verify.
And
It's a risk of certiorari. We'll certify the records. What affidavit is required?
Lordship, we submitted document and it is also written in the judgment that we had not submitted.
Okay, we'll see that. Perversity.
Yeah, Lord.
Before that, we'll see what is your right.
Lord.
Not to be evicted.
Yes.
Prima facie, you'll have to satisfy
Lord.
that this is your right. Issuing a notice must have a, suppose it is without a notice or you have been sought to be evicted, there is no boundary. You show us something prima facie that this is our legal right. So therefore, this is not applicable.
Lordship, we had some judgment
Oh, judgments, there are crores of judgments.
in that case.
It depends upon facts of the case. Day after tomorrow, Thursday. Huh? Or Tuesday, next Tuesday.
11.
Huh?
11.
Huh? Huh?
First week will be difficult.
Thursday. Okay, Thursday.
14.
It
11. 11.
Huh? 11th.
14, I will out of
11th.
11.
11.
11. It is submitted that an affidavit in
Additional affidavit was filed
additional affidavit was filed on.
on 7.
Is it on record? No, he said something he has filed.
But we could not
the-
receive the
any-
copy, so could not file the reply. But in the case of the affidavit, we have replied on
On last Saturday.
last Saturday.
Okay, it is submitted that and reply affidavit has been filed by the petitioner on
2nd of March.
2nd of March. Registered to verify and take the same along with the record.
Okay.
List this matter on 11th.
I leave.
I am preparing for the respondents. Petitioners file an application for including the company as a.
They want to say that so and so is our officer,
No, Lordship, it will
Anu
not-
Singh.
Just inform me, Sunil, Gowal, Lordship, can it be taken after sometime or any other date? Yes, sir.
Why?
He has some inconvenience, he just contact me over telephone to take adjournment. Timing.
I'm not getting it.
My lord, he just informed me to take adjournment for the timing.
Other
Who?
Mr. Agarwal is appearing.
Okay.
Yes, some part.
Okay, there is none. Okay.
Some other day.
Some other day? Okay, I'll, on the prayer of the learned council for the parties, list this matter after a week.
May I please your lordship?
Yes.
Mr. Sharma has some medical emergency.
Who?
Mr. M. Sharma. May
Who is
kindly
he?
pass over the matter.
Oh, forget about him for the time being. Yes, Mr. Batra.
We have admitted the policy,
Huh.
but only the, we are trying to find out the agreement where they are required to submit us with the intimation and all these things are required. So we written to the Bombay office. While filing the affidavit also, we have stated that. but
No,
till
that we
now-
know that now Axis Bank may not be very necessary for the time
No,
being.
no, they are necessary party.
No,
because-
they are necessary
Yes.
because initially they are the parties against whom this was
Yes,
filed. They
yes.
took a stand, some stand, then court observed that then it will be a fraud upon the people.
Correct.
If you say that we have not decided and we have given way, then thereafter you said that yes, no, in fact it was New India or something like that.
Yes,
Now,
policy was admitted.
now what to be done?
Well, only whether they have submitted the claim within the
No,
time or not.
Hmm.
That has to be, the bank has to say,
Yes.
because we are until unless we receive
So
the
no,
information,
who will make this claim?
well, the claim will be made by
By
the
the,
petitioner to the bank and the bank will intimate us.
yes, bank.
Yes, lordship, Mr. Sharma is unavailable due to some medical emergency.
What medical emergency?
He is not available.
When will he be available?
Maybe tomorrow, lordship.
You have that instruction. No, so Mr. Batra, your stand is that we will honor it,
Yes,
provided we have been given by the materials to honor what
Yes,
is required.
Yes, fine.
This
We
is
have,
your
ad-
case.
yes, we have admitted.
You
the
have
policy.
admitted the policy,
Yes.
but payment will depend upon how the bank proceeds it.
yes.
And his responsibility is to file an application. Yes,
Tomorrow.
please have the instruction tomorrow, not tomorrow. We are fixing it on next Monday, but we will not adjourn on that. Mr. And you are?
Yes, ma'am.
S. Yasmin, Learned Counsel appearing on behalf of Mr. M. Sharma. Six further, 6 a week's time. To obtain, to obtain instruction how the bank has proceeded pursuant to this court's order dated 20/12/2023, inasmuch as the insurance company has taken a stand that inasmuch as it is the stand of the insurance company that though they admits the issuance of the insurance policy, however, the claim can be honored only when bank proceeds in terms of such insurance policy. Full stop. Therefore, full stop. Accordingly, adjournment stands granted. List this matter on 11/3/2024. On the said date, the Learned Counsel for the Axis Banks shall apprise this court how they have proceeded after filing of application dated after the claim was made by the petitioner before it. List according.
May I please your lordship, my lord? This is a matter.
So this has become infectious
So much. That is not in fact.
according to this court's observation.
My humble.
This court, however, finds very pertinent to observe that this rejection have not been put to challenge, and under circumstances without challenge to the said documents, nothing remains to be adjudicated in the instance.
My lord, first, we have challenged the impugn order dated, my lord. Passed by this, my lord, day, my
Okay,
lord.
what you want, you made it and then.
What happened in this case, last occasion was honorable court directed me to file an additional affidavit
Mm.
to being on record if advised of it,
Mm.
the minutes of the meeting
Mm.
and the comparative statement.
Mm.
The documents, what have been submitted the applicant
In the,
in the main, in the for allotment of the room lawsuit. As
Okay.
per the guideline of Supreme Court, I have that documents.
Mm.
I send it for vetting lawsuit. I will file it today itself.
okay.
My lord, one thing is that, my lord. There are, my lord, two parts.
Mm.
First part is that they have settled the room, my lord, by violating the order passed by the Honorable Guwahati High Court
Mm.
as well as, my lord, Supreme Court. my lord. When we were challenged this. That part was not decided. Only thing is that Honorable Court has said, subsequently they have settled, my lord, we directed the Honorable Court to produce some document, my lord, and we produced the document, my lord, and thereafter they, one line is settled that where their case could not be considered.
Mm.
They are not. So the last time, I think they have directed to produce all the document along with the record of this case, my lord.
Mm.
As per my.
Only
Only
thing
thing,
if
my
any
submission
advice.
for your lordship is that, my lord.
Last
What happened, my lord, in the instant case, my lord?
Mm.
It's a very tricky case, my lord.
Mm.
They have done. There is as per my lord, after my lord put safety bill must come, my lord.
Mm.
This body is non-existent
No,
body.
no, this is.
Assam Agriculture and Marketing Board.
Mm.
And they have, what happened, my lord? In connivance with some people, my lord.
Mm.
If you are a syndicate, my lord. And that syndicate, I have produced all the document, we are asking for the CM vigilances, everything is here, my lord.
That is it a subject matter?
Yes, sir, it is a subject matter, my lord.
What are your prayers?
Yes, my lord, you will also kindly come to the prayer, my lord. And thereafter, this honorable court passed an interim order, my lord. Now, interim order still exists, my lord. Why marketing board has said, why municipality said, my lord, in their miscases category, say, we are the genuine vendor of BASFA, my lord. They have admitted, my lord, in IA case, my lord, IA number, my lord, 552 or something, my lord. Honorable say, and so the pass is 1852, my lord.
Don't take names of the judges.
Sorry.
We are all courts,
Yes, sorry.
not by name.
I'm extremely sorry. In the premises, therefore, your lordship may be decided, please to admit this petition. for-
Okay. What you want to bring on record?
Lordship, what happened, Lordship, the petitioner never applied for the.
Okay, we understand. This court have prima facie taken a view that in terms of 1B and 1, 2, 3,
Lordship.
they are not entitled. So therefore, this is one aspect. That is not yet being finalized, this is a prima facie view. And second part is that court observed that since the order by which their cases were rejected are not under challenge, this petition has become infructuous. So anyway, now they have filed a writ petition.
Okay.
And they will make a submission in that it should be taken up along with this writ.
Yes,
That will happen. Now you file that IA whatsoever.
Lordship,
Okay. The learned counsel for the respondent number.
respondent number, Lordship.
and another thing is that, my lord,
For-
if your lordship,
TN6.
order of the 1852, my lord,
Mm.
categorically stated, my lord, in that, my lord, the first you have said, the Masqua people, my lord.
Mm.
That part is cleverly, my lord, waived.
Order,
We'll
Lordship, there's.
No, we are not deciding anything today. So we'll go through all this aspect. It's not that something has been, no decision has been taken, a few has been expressed.
I am for TN6, respondent number TN6,
Respondent, learned counsel for the respondent number 3 and 6 press for an adjournment to enable them to file an additional affidavit. Prayer is allowed. List this matter. When your matter will be listed,
My lord, it was this, along with the filing, I have got the filing number. but-
okay, move it, we'll fix it after a week.
Lordship.
After a week.
Lordship.
And my lord, the most important thing is that, my lord, 1852 order, my lord, categorically stated, my lord.
We'll consider.
One thing is that,
Mm.
my lord, we are the genuine vendors, my lord.
Mm.
And
But they have not.
there is also a genuine vendor. All the document before.
No, Lordship, they have to.
No,
Big
don't
document.
argue.
My
Today
humble
we are
submission-
not deciding anything.
One thing is that my previous case is that, my
No,
lord.
we'll see. We'll look into every
Yes, my
paper.
lord. Yes, because
We have adjourned today,
we
not
are-
ne-
we are.
Mr. Chaudhuri.
Yes, my lord.
Mr. Chaudhuri, keep your energy for the next day.
Yes, my
Why
lord.
you waste your energy?
One
Also, can
thing,
you fix
one
the
thing
deadline
is that
of-
he is for this for the stronger section of the society. I am the weaker section.
No.
They can run the syndicate, my lord. No one can do
Lordship, they
anything,
have
my
not
lord.
submitted
Because my
any.
previous-
We'll see, we'll see, we'll see.
My
we'll
business
see.
is also dead, my lord.
We'll see.
There is no
The
syndicate is
previous
going
case,
on.
my lord. This
We'll
is my
see.
No
previous
syndicate
case.
is going.
Next case,
Then
Earlier,
the
Lordship.
inquiry where the syndicate is going on, my lord.
next case.
Why, my lord, marketing board is, my lord, cover up those people, my lord, who running
You
the
keep
syndicate.
your energy for the next day.
That is the thing.
Energy preservation is, and you want to burn energy, there are some other places.
No.
Yes.
Lordship, this is a matter, your lordship, regarding correct name of a.
What will decide? Division bench has decided already.
Lordship, decided is other matter.
Other methods, but involving the same property.
Same,
There was a guideline.
lordship,
There was a dispute whether it is an Idgah or it was some Bakori, Chitrabon Bakori. This is one aspect. Other aspect was that whether it should be only permitted for religious things and construction should be allowed. Division bench says those construction which has been done on the basis of a report of a deputy commissioner. The report says that these are illegal constructions. Demolish it. And morning workers and others will be given permission. Fine. And deputy commissioner says that will give as per our wishes, but no religious puja because it was used for Idgah.
Yes.
So they have made a balanced decision. That report is not under challenge before anywhere. Division bench accepted that and closed this PIL. Now you want that this is a Idgah for time memorial. It was never a Bakori. Now how do we decide? Highly
No, no, no,
substitute.
your lordship, it is not to be decided, already matter has been decided, your lordship.
Mm.
Now question is your
What is the
lordship,
prayer here?
where your lordship,
Prayer was that they are having this program. Some 26th.
so lordship, just a minute, your lordship.
Mm.
The other matter your lordship has referred, your lordship, that is a PIL.
Huh.
In respect of your lord, of illegal construction within the Idgah
Uh-huh.
by the committee, because that why it is illegal, your lordship,
Hmm.
without permission of the municipality board, your lordship, it was. And that matter has been decided, your lordship, that these constructions are not.
Now,
With due
Mr.
permission-
Mr. Ali, you are a seasoned civil lawyer.
Lordship, I can't say.
You are a
lordship-
seasoned, one of the most respected civil lawyer. Now see your prayer. Can we make this determination?
Lordship, not to be determined also, it is already there, but they have misused the word, your lordship, Sitravan, your lordship, taking it quit or making it a prefix, your lordship, with the Idgah Maidan, your lordship. That is, Idgah field is different field, and this Sitravan Bakori, your lordship, it is upon 2 quarters of land within the Mahakuma.
That is the difficulty in sitting here to
No, no, no.
26.
I will convince your lordship from the.
In a repeat court that this Dag, Sitravan is situated in this Dag, Idgah is situated in this Dag.
Lordship,
And I'll have to say that they are
No.
Sitravan and Idgah are two different
Not
things.
necessary, your lordship. There are a number of documents I have annexed, your lordship will be convinced. Your lordship will be convinced that it is all along Idgah since 1908. In the 1923, your lordship, it has been allotted to Idgah. No Sitravan, your lordship. Now the word Sitravan has been added, your lordship, since 1975, then 2018 in all other correspondence. We have objection to that. Nowadays, your lordship knows that Idgah, your lordship, wherever Idgah, number of Idgahs are there, your lordship, all over India. Now, your lordship, Hubli Idgah, your lordship knows there is a perennial dispute, Hubli Idgah in the Karnataka. So these things are very sensitive. That's why, your lordship, when any correspondence is issued by the respondent, the only word Idgah should be used, and in the letter or in the address, your lordship, no Sitravan Bakori, because Sitravan Bakori has been introduced
Okay.
by later.
Okay, we'll allow this repetition.
Lordship.
We'll allow this
Right,
repetition.
lordship.
That this Idgah should be always addressed as Idgah, not as Sitravan Bakori.
Right.
Okay, fine. We'll pass this repetition. Allow this repetition. Now we'll have to allow this, we'll have to have some determination that this has been Idgah since which year you said?
1908.
1908. This
That
has
means,
been
your
this
lordship-
has been an Idgah, and the Sitravan is used for the first time in 1975
then
and thereafter in 2018.
18.
Therefore, on the basis of this, it is to be said that it has already been Idgah. So you say that the documents you have relied upon, on the basis of that, we will have to make a determination. Is it permissible?
It's permissible, your lordship, because they have misused the authority, your lordship. The respondent have misused.
Okay, are good.
Lordship will come,
Okay, you are good.
page 22, your lordship will
Yes.
come.
Yes.
Page 22, annexure 2.
Yes.
Your lordship got it, your lordship. Annexure 2, page 22.
Hmm.
Your lordship, sit up for surveyed villages as per the order passed pursuant to on the basis of the application number so and so filed by Sri Abdul Hamid Pepari, the certified copy of the sit of that number so and so of Muja Mahabharat Tezpur town is issued. Land measuring 3 bigha 4 kota 11 lessons covered by like number 330/1. Mohammedan Idgah as per order the duct number 330 is preserved for Idgah. Is preserved for Idgah, your lordship. And it is the Mohammedan Idgah. So for this original is in Assamese, your lordship. And from that also, your lordship, in next page, your lordship will find 3 bika 4 quarter 11 lessons, Mohammedan Idgah 3/30 duct gor for the Idgah or Babe Kaim. That means, your lordship, this has been allotted to the Idgah, your lordship, since the year, officially, your lordship, since the year 17/4/2020 or 1923, your lordship. 1923, your lordship.
Mm-hmm. Page 23.
Page 23, the Assamese portion, your lordship.
Oh, yes.
English version is, your lordship, penciled annexure 2. At the bottom, your lordship will find it is dated 17/4/23, 1923, your lordship, not 2023.
Yes.
Then your lordship will come to 6, your lordship, annexure 6.
Page. Page.
Annexure 6, your lordship, page at 44, your lordship. Revenue Settle Department, Settlement Branch, Soincho Deputy Commissioner, reservation of land of Mahabhairav Moja of Tezpur town for Idgah and other public purposes, Reference Soincho. In suppression of government order issued in this department's letter number Soincho dated 21/7/1971. I am directed to cover the order of the Governor of Assam as follows. The land covered by duct number 1828 and duct number 1829, that is the present duct, your lordship, of Mahabhairav Moja Maidan within Tezpur town may be kept reserved and its maintenance entrusted to municipal board subject to the following conditions. The Muslim community, the Muslim community may be permitted to use the field as their Idgah Maidan. They may be allowed to use the field exclusively for their religious functions during Eid masses, prayer days on account of Idul Fitr and Idul Zoha. No permission for performance of any other religious function by other communities should be granted. The field should be available for use of playground of all communities. Public meetings and other non-religious functions should be allowed to be held without any discrimination. Permission to use the field for such and such, your lordship. Now your lordship will find that this is the field, your lordship, only reserved for Idgah. In that Idgah.
Not only reserved for, it is being used, allowed. If we go by this document, page 44, what is the intent? Intent is Muslim community may be its land cover under Tezpur Soincho reserved for its maintenance, entrusted to the municipal board subject to following condition. So it will be managed by municipal board subject to following condition. What are the following condition? It will be allowed, permitted to be used field as their Idgah Maidan. They may be allowed to use the field exclusively for their religious function during Eid Mas prayers days on account of Idul Fitr and Idul Zoha. Two occasions specifically you can use. No permission for performance of any other religious function by other communities can be granted. That is the report of the Deputy Commissioner before the PIL, and court accepted that. Now come to the field should be available for use of playground for all communities. Public meeting and other non-religious functions should be allowed to be held. Non-religious. In the PIL also, the Deputy Commissioner took a stand that puja, etc. will not allow. That clicks the matter.
No, the subject matter of this petition is not that, your lordship. It is that you can't use the word
within bracket, either prefix or the suffix, your lordship.
That is the difficulty in the read code. Can we decide what name should be
No,
given?
no, no, that is not dear, your lordship, since 1908, 1923, 73, 1941, your lordship, I will be coming to those documents. You will find all along it is Idgah Maidan, your lordship. It is Idgah Maidan and nothing else. Now, later on, they have added the word, your lordship, Sitravan Bakore. How Sitravan Bakore came, your lordship, to be used along with the Idgah? That is not permissible, your
Who are you, Mr.
Yeah.
Go?
There is
I am
that
the,
is
my
not
lord, ingredient,
permissible.
my lord, the
How can we add?
person who filed the PIL, my lord. And
Okay.
respond number 3.
And
here.
who is the deputy commissioner? What are you doing for all these years? What is your stand?
Please, traffic ground now.
Where is your stand?
Our academic very little, we have got 5.
You bring on your statement. Okay. Heard Mr. S. Ali, learned counsel for the petitioner. You will make it specific. Mr. Goswami, learned counsel for the, just a minute, we are not deciding today. Mr. Goswami, learned counsel by a week.
Okay.
Chaudhary and Mr. G. Chaudhary for respondent number 3. The grievance raised in this writ petition is that a plot of land measuring
Measuring, your lordship, 3 biga, 4 kotha, 11, let's say, your lordship.
a plot of land under Mouza Mahabhairav
Mahabharata.
is being used as Idgah by the Muslim communities of Tezpur town since
1908.
1908. 1908. And it is known as Idgah. It is known as Idgahs. However, according to the petitioner, the district administration has started addressing / naming the said ground as
And Idgah Maidan within bracket.
Idgah Maidan
Bakori,
within bracket
and within bracket Sitravan Bakori.
Sitravan Bakori,
And sometimes without bracket, your lordship.
and sometimes it is being named as Sitravan Bakori.
Your lordship.
This is the grievance of the petitioner, that the said
Sitravan
field,
Bakori.
said Idgah should always be addressed and treated as an Idgah and not as Sitravan Bakori. This is your case.
Lordship.
This is your case. Full stop. Mr. Goswami, learned counsel for the respondent number 3, referring to an earlier decision of this court in PIL 100 of 2015 relating to the land in question, has submitted that the district administration, that the land is a Sarkari land and it has been used as Idgah for the purpose of Eid during the Eid festivals by the Muslim communities. However, the other functions are also being allowed in the said land. And why you have used it as a Bakori notes then? Full stop.
It was all along known as a Bakori, my lord.
Okay.
What
It is further submits that he may be granted a week's time to bring on file an affidavit to respond to the pleadings made by the petitioner. Full stop. Prayer is allowed. List this matter on 13 03 2020. You file it, the affidavit, because we will have to decide what is your stand. Okay.
Lordship may kindly keep this matter as part of my.
No, not part. It will be 13.
I'm
But file the affidavit. He is having a grievance. Let him know why Chitravan Bakor. If he is saying, tell us, supporting with, it shows something, but Mr. Ali, it's a difficult proposition for a read court to give a finding on a disputed facts on the basis of the materials in your favor.
Lordship, they have created the dispute, your lordship, the other.
No, they
all
have,
documents
we
are
understand.
fine.
They have created, according to you, there is no dispute. It
Correct,
is the
They
Idgah.
have created.
According to them, it is the Citrabon. Now, how a read court decide whether it's a Citrabon or Bakori?
Behind Citrobon, there is a force, your lordship, and they have.
Oh,
included
Mr.
your-
Ali, this is a 226 code.
Lordship. That's why your lordship, the document says all along your
That's
lordship.
why this court, in a disputed situation, cannot look into the documents. Now, then we'll have to bring the box here.
Not necessarily, your lordship.
My
the
lord,
document should-
If there is no dispute, if deputy commissioner comes and says that, yes, it was never a Citrabon Bakori. It was a Idgah and this is Idgah.
Today's deputy commissioner can't say, your lordship, 1908, 1941,
next.
73.
Next.
These documents
Next
are
case.
here, your lordship.
Now
Today's
we'll do that
deputy
also.
commissioner is
Okay,
prior to
we'll do that. Yes,
Actually, to copy.
yes. Item number?
Item 14. If I the petitioner here in my lord, they are occupying a small plot of land, established there, my lord, small shop.
Hmm.
And that land has been, my lord, allotted to Koborostan mine. And another plot of land, my lord, allotted for set up, my lord, public health sub-center. And thereafter, my lord, the circle officer,
Hmm.
my lord, issued the notice to the
Hmm.
shopkeeper, my lord, to vacate the place. My lord, notice at page 12, my lord. Notice has been issued, my lord, under rule, my lord, 18(3) of Assam Land and Revenue Regulation. That is violation, my lord. Circle officer cannot, my lord, issue the notice under rule 18(3). My lord.
Hmm.
Only the deputy commissioner or sub-divisional officer has power. Amendment to the rule.
Where is the order of the circle officer?
Sir, order is, my lord, page 12, notice,
Notice. Yes?
page 12. Particular at page 30.
Now what happened thereafter?
Thereafter, my lord, the petitioner approached the Sonapur court.
Hmm. Now what about this Board of Revenue order?
So that is, my lord, they dismiss the appeal. Last time, my lord, because this is a government act,
Huh.
they approached the revenue court and revenue court, my lord, dismissed.
No, where is the under what provision you have preferred revenue appeal? 147?
Yes, my lord, 147.
Against the circle officer's order?
Yes.
It will lie before whom? Okay, deputy commissioner or circle officer, so it will go to Board of. Is he in a scope for appeal under 18(3) in the Board of Revenue?
I'm not sure.
Because see, this order is also under challenge. Board of Revenue. Can it be an order by a board, first appellate authority? If appeal is maintainable. Kindly come to page 28. If appeal is maintainable, this will be a first appeal. Can a party be thrown out like this from a statutory appellate authority? So you admit that this is a government land? Huh?
Yes.
Now, if it is a government land, what is your right?
My lord, we do not have any right, my
Hmm.
lord. Land is, my lord, already allotted.
Hmm.
That plot of land has already been allotted for Koborostan.
Huh.
And for committee of Koborostan, they have no objection.
Hmm.
And they set up their small shop, my lord, nearby the road.
Okay, you are a tenant under Koborstan.
Yes, my lord. And they have no objection. But, my lord, another plot of land was allotted for, my lord, setting up public health center.
Hmm.
And the public health center, sub-center, my lord, instead of that plot of land, they occupying this land,
Who is
That is the-
occupying this land?
this, public. Land.
You have been allotted,
We are.
your
alone.
government's case is that this land belongs to Gurstan,
Yes. yes,
Qabristan. Now, Qabristan land, therefore you vacate it.
So
Now, what
they-
is your case?
They have no objection, ma'am.
Who?
They, Qabristan
For-
committee.
Forget about the Qabristan time being.
Right.
Now, what is your case?
My lord, our case is, my lord, nearby the road, my lord.
Uh,
We established.
You are the
established small
Qabristan.
shop. Small shop.
You constructed or Qabristan
And
constructed?
they are not prejudiced, my lord.
Answer my
Subset-
question. Who constructed these shops? You or the Qabristan?
Petitioner.
Petitioners.
Yes.
Now, where is the allotment in favor of the Qabristan?
Allotment is not there.
Then it's meant for Qabristan. Committee will not become owner of a Qabristan.
No,
How can you be allowed to obstruct a land for Qabristan?
they have no objection.
To their objection is not issued. The government is having objection.
Government, my lord.
Because government says we have given this land for Qabristan and some people are occupying. Qabristan, member of the Qabristan committee is taking rent. Isn't it? Monthly. So they will not object because that is their source of income. But whether that is permissible. Show us that this land is allotted in the name of Qabristan and Qabristan is having a right, committee is having a right to do and run a business from there. We'll throw out government. Who are you to involve? You have allotted, you have settled, they are paying land revenue, so matter is there. You cannot evict the tenant of Qabristan. But show us the allotment in favor of the Qabristan.
They did come after we, I have to update something.
But your basic fundamental ground, they have said that no, there was an amendment in the year 2010 itself, where it has said that it should be deputy commissioner
Judgment.
or circle officer. No separate delegation is required. How many shop owners?
Altogether 7, my lord. 8.
Government file affidavit.
No,
File an affidavit, short affidavit. Who will, you are for?
I'm for revenue and disaster management department.
Somebody should file an affidavit that this is the allotment of this land or this is the Jamabandi or something like. Have the proceeding of this 18-3 proceeding.
He'll be there with the police.
The learned counsel for the state respondents submits that he may be granted some time to file an affidavit or obtain the record of the relating to the impugn notice issued, notice of eviction. It's impugn notice of eviction. Full stop. The learned counsel for the eviction. Prayer is allowed, please accordingly. On. Please accordingly after 2 weeks.
Alright.
Interim order,
Obliged.
Passalia shall continue till then. Right.
Directed to
Whether released or not,
Lordship, I do not have any.
you can say important issue.
From the brief of my friend, it
Ah.
appears there has been some confusion. Confusion in the sense, Lordship will see, he was convicted by a court holding him to be a Bangladesh gold brother.
Mm.
And the
Under Foreigners Act.
yes, yes.
So he was 6 months. Now
But,
6 months is over.
yes,
He says, let me go.
no, the difficulty here is we have to inform the other country.
So we want to know that what have you done?
There lies the confusion. What has happened here is, from
Mm.
what I can see,
Mm.
the issue was taken up with the Ministry of Myanmar. It should have been,
Bangladesh. So you obtained that
Yes.
instruction because lawyer is also is not representing him.
Lordship, I will take that.
Okay. Uh, Mr. R.K.D. Choudhury, Deputy SGI, referring to this court's order dated 5/2/2020, submits that probably communications and personnel data were of the petitioner were wrongly sent to
Myanmar,
uh, to the
Repu-
to Myanmar.
Republic of the Union of Myanmar.
Is the to Union of Myanmar. However, it should be to the what is called Bangladesh, whose full form of Bangladesh. It is
It's Republic of Myanmar.
it's a Republic of Bangladesh. Full stop. Accordingly, he seeks for referring to লিখলো না আরম্ভ করছে so and so full stop. Accordingly, he seeks for an adjournment to obtain accurate instruction and status of deportation of the petitioner to his country of origin.
First, it will give me
3 weeks. But it's urgent. It's a,
Yes, yes.
ultimately Article 21 is applicable to the foreigners.
That will not start for regarding the filing of the FR.
Yes.
The FR was not accepted.
Now, if not accepted, it will continue. What, anything survives here?
Compensation part also there, my lord, but if please find that the miscreant has taken the son of the prisoner, then compensation part will come. Otherwise, nothing.
Not yet accepted means it is not been placed before the court. Now, suppose it is accepted or not accepted. What can this court decide after the investigation?
It will decide my lord, on the basis of my finding of the my lord report.
Uh,
If it is find that my lord the incident took place because of miscreant or my lord kidnap my lord, then my lord execution will get, family will get some execution. That is the only
compensation under what?
under my lord notification my lord. Page 23 my lord.
Who will pay that?
Revenue due.
Huh?
Revenue due.
Revenue Department or Legal Services Authority?
Because in case of murder case,
Okay.
page 23 my lord. That is the only. Matter may be fixed after 2 weeks.
Okay. Now, who will place before this, it is before the court? Who will place it before the court? Not accept, this is all vague thing. Not accepted mean whether it's rejected or reinvestigation given or a cognizance is taken. Is it an answer? Whether it was placed before acceptance or it is accepted, not accepted means what?
The court not accept.
It is not placed. The records of Jeremy have been verified and it is reported that FIR is not yet accepted. The yet word is having meaning.
I have the FR number.
The FR number we are also having, that has been recorded.
Look.
The question of this court is whether what happened hereafter.
Look.
Who will bring this instruction? PI, prosecution inspector. Of which court?
Golpara.
Call a public prosecutor after something.
Okay.
Call one additional or any public prosecutor. We'll have to take our responsibility.
Yes.
It is our job now.
No.
You will just produce a document. Not, you have no question to your SP. What not yet is accepted? Did you place it? This question will definitely come from the court. You are not a postman. You are a lawyer. You'll have to ask. What happened? Why not? Did you place? Did you, your PI placed it before the court? Isn't it?
Sure.
Call, bring some public proceeding.
April also. So I'm appearing for KSC lordship, Karbi Anglong Autonomous Council.
Uh-huh.
I'm appearing for Karbi Anglong Autonomous Council lordship. Lordship, in this matter, I'm praying for some more time lordship to obtain instruction lordship.
What instruction do you want? This
Regarding
is item number?
regarding joint verification lordship, which is to be conducted by the KAC and APGCL lordship. So I need some more time to obtain it.
Where is APGCL?
I'm appearing my.
This instruction we are awaiting since November 2022. Yes.
I'm praying for previous lordship.
Will observe that in the event they are entitled to pay, there will be an interest above the base rate that has been provided in the ex-statutory interest, and that is for the delay here, and the officer who is responsible for not giving instructions since 11/11/2022 shall be liable for payment of such interest.
Lordship, we have filed an IA lordship, one IA that is disposed of 21/12/2023 lordship.
What is
Filed
that
is
IA?
in the IA lordship, 3480.
IA. What is that?
And Honorable Court has directed us to do the joint verification lordship.
When it was done? December.
Yes, 21/12 lordship order was passed on 21/12.
Now, whether that has been done,
That instruction I have not yet received, lordship.
you have a phone.
Yes, lordship.
You have a phone. Come back at 2. Or your officer will come tomorrow. Come back at 2. What happened after this order dated 21/12/2023? Whether joint verification has been done. We are in the month of March. Anything done, Mr. Counsel?
Lordship, my instructions are that they had gone there, the joint team had gone there, but it was not completed, and then they are supposed to.
Okay, when have you done? And by what time you can complete the joint verification? Give us that instruction today at 2.
May I please?
Yes, Mr. Go.
My lord, in this case, my lord, initially the section number 6 and 7 started a construction of building, my lord, ground floor 4.
Hmm.
Thereafter, my lord, after filing this petition, my lord, they dropped that plan, my lord. Now they have constructed, my lord, RC with RCC, still structured, my lord, ground floor 1.
Hmm.
So, and leaving my shop aside, so I know.
Okay, the learned counsel for the petitioner, Mr. J.C. Gore, submits that he may be allowed to withdraw this writ petition.
My presence may be recorded.
Okay,
Section 7.
with a liberty to approach if any grievance, if any cause of action arises. Mr. Bora is present representing the
Section 7.
respondent number 6 and
Private.
full stop. Accordingly, writ petition prayer is allowed. Writ petition stands dismissed on withdrawal with the liberty as stated.
Problem.
Thank you. Okay, I see.
May I please?
Yes, Goswami,
Lord.
here is an issue.
Lord.
There is an FIR
Lord,
that his son is missing. Now, he files that police is not investigating, then a produce the body, kidnap and something like that,
Lord.
with a prayer for compensation.
Lord.
Now, this court monitored the investigation. Finally, a body was found in a wet water body.
Lord.
It was recovered, sent for forensic.
Lord.
Ultimately, forensic says his DNA is not matching. Then subsequently, FR was filed. Okay. Now, what is the content of the FR? That is one aspect which will have an impact upon the compensation. Or if it is now, we sought an instruction from the Learned State Council
Yes.
that they will give us an instruction what happened thereafter. Now they got an instruction which says the record of GR branch of Honorable Court have been verified, and it is reported that nobody is clear, nobody is giving any responsibility to anyone. It was reported that the FR is not yet accepted. So FR is rejected will a different meaning, not yet accepted will have a different meaning.
Lord, not
So
yet.
not yet accepted means it might not have placed before the court till now.
Yes.
Then only court will apply. So we want
Maybe-
an instruction that where this is pending from PI.
Lord,
This will be from the PI only.
yes, PA or my lord, we can, my lord, verify from the IO also, my lord, regarding to
Huh.
but he will be the best person to know, my lord, whether he has submitted or not, or whether it is accepted or not.
Accepted. Suppose if it is not accepted, it is not acceptance will come when that final report will be placed before the
Then it will
CGM.
go for further investigation.
A court may then will go through it, then issue a notice to the informant.
Lord,
There may be Naraji petition.
Lord,
So
there-
this instruction is nothing.
nothing, Lord. Or,
Who will give this instruction? Why should we burden him, Mr. Goswami?
Lord, and another thing, my lord,
Pursuant to this court's order dated
Lord,
9/2/2024,
Yes.
Mr. N. Goswami, learned government advocate, has produced an instruction from the Superintendent of Police, Gwalpara, Assam, which is in the considered opinion of this court, is not clear and do not answer the query that has been made by this court under its order dated 9/2/2024. It is not clear from the said report whether the final report submitted by the investigating officer being FR number
FR number is 33/23,
33/2023,
dated 28/2/23.
dated 28/2/2023, filed in connection with Lakhipur PS case number 337/2017, has actually been placed before the learned jurisdictional magistrate
Or-
for consideration, or whether such consideration has already been made full stop. Accordingly, Mr. Goswami shall obtain specific instruction.
No.
When such FR was submitted.
No.
And whether that has been placed before the learned judicial magistrate for consideration. And if so, what is the decision of the magistrate thereof? We are saying the N Goswami, not you, though we have, because this is his responsibility. Why
Lord.
should you burden you?
Yes.
Huh?
And
You can
another-
have a telephonic
Yes,
instruction.
yes,
We are
and-
not recording your name. Give information.
Lord, another-
List this matter on. This is a telephonic instruction only. A father or a parents has lost their child. It was a responsibility to protect that child by the state. Now, even if it is a final report, it may be its case is true, but we could not have a clue. This is the result.
No.
Then also, fact remains that his son is
Right.
killed. So parents may be entitled for some compensation. That much we want.
I will
And
at
for
least
that,
tell
we have already spent 15 minutes.
another aspect, my lord, subject to correction, my lord, whether a report can be called from the CGM, my lord, Gwalpara. Because
Huh.
it's
Okay.
short for registry.
Registry, registry shall call for a report from the Chief Judicial Magistrate Gwalpara as to whether the
FR has been submitted.
whether so and so you can FR so and so has been placed before it.
Status of,
So, okay.
status of the ZR case.
List, give a date. 12th of March.
Published. I'll let it take.
Yes. Yes.
May I please, Lordship? Lordship, here the matter relates to the land acquisition lawsuit.
Mm,
Petitioner is the owner and possessor of the civil land lawsuit.
mm.
Find the response number 3 issued a notice for demarcation lordship for construction of one MNP road. So finally come page 19 lordship and accept to it. Page 19,
Annexer.
page 19. Yes, Lordship.
Now, what about your additional affidavit?
Additional affidavit lordship, that phone number 3, page 26 lordship, para 6 lordship. They have said that said land was taken by the Deputy Commissioner of Kalsat in the year 1989.
No, there is a specific direction by this court on 5/6/2023.
Or-
The petitioner shall file an additional affidavit to support their contention that they have any kind of title in respect of the plots of land covered by DUG numbers mentioned in the affidavit dated 9/4/2023.
And also, we need to submit it, lordship. In the meantime, lordship, response number 3 has filed their affidavit in opposition, lordship. In the state affidavit in opposition, lordship, they have stated that the state land is belongs to the petitioner, lordship, which was acquired in the year 1989, lordship. Kindly come to the page 26, para 6, lordship, of their affidavit in opposition. Para 6, lordship.
Just a minute, just a minute. Where is the affidavit 9-4? Where is the affidavit of the respondent number 3?
There are six, page 26 of it. There are six of it.
Where are the private respondents? Paragraph?
Paragraph 6 of it. Of affidavit filed by the respondent number 3 lots. That is circle of the term.
What is your prayer?
Here the petitioner have no objection for any lordship development or work lordship.
Hmm.
But they have not paid for the compensation as the said land was acquired as per their statement given by the additional affidavit lordship. But the petitioner has no knowledge whether
Additional affidavit by whom?
respondent number 3 lordship. But so additional we have to lordship, we have not submitted to just we receive it.
No, wait for a minute. The circle officer at paragraph 7 has taken a stand that yes, you were the owner and possessor of the land mentioned in the schedule below through inheritance, but 1989, the said land in question was made khas for construction of road. So without giving them compensation, you made it khas. Under what authority?
It is has government, has landlord.
No, in your
Paragraph-
affidavit, you say they are the owners and possessors. If they are owners and possessors, either you can take back, you can take the land, no problem on that.
Yes.
But can you make it khas? Means the settlement character is cancelled. What is a patta? Ownership, what is a patta?
Yeah,
You settle a land for a period. Now you think that, okay, fine, we want a road. Why should we give compensation? Make it khas. This is your
It is-
statement. It's absolute illegality. You cannot say that this order is not under challenge.
on paragraph 8 also of our affidavit lordship. Here it is said that on that available.
Now
of
forget about all these things. What we are not saying that they are entitled for a land or that you will be stopped to construct a public road over anybody's plot of land. No problem on that. Question is, according to you, they were owner and possessor. Now we have made it khas. Where, under what provision? Tell us. Where is your power?
It was already has government.
No, they say that they were, see, read this paragraph.
Yes.
They were owners and possessors of land mentioned in schedule below through inheritance. But during the year so and so, conveying the order of Deputy Commissioner Kansar, the land in question was made khas for construction of road. Can you do this? And as such, petitioners are found to have no title possession over them.
They have also not annexed the order of this order lordship.
Where is that?
They have also not annexed the order lordship.
Where is that order?
Order is not.
Yes, private respondent. What is your case?
We are the villager, lordship, we have no any alternative road, lordship, except if another road is there, which is the other road, lordship. Cases cannot allow us to run each and every time, lordship. So what to do, lordship, without this.
Okay, we'll ask that you have an alternative land over a different plot of land and make it khas.
Since our inception, lordship, we are using this road.
No, we'll ask them that make it khas. Do you have land?
No, lordship, no alternative road.
No, no. Do you have land?
No, this is a road, lordship.
Road? No, no. You are having, the villagers are having land. We'll ask the PW to make a plan
Other
and to
roads-
construct a road, and we'll say that don't give compensation.
no,
make it
lordship, no,
khas.
lordship, if they have.
Make it khas and take the
They
land.
have entitled to compensation, lordship.
That is what.
That is what.
We'll have to balance. We'll have to balance. We know that they can construct a road, no problem on that. They can acquire their land. They are also saying that we don't have any problem.
We have no objection regarding their compensation.
Yes,
but
madam.
they have any entitlement.
Also,
But road is required, Lord.
Huh?
here also it is mentioned that road was not.
So road was not constructed. Now what do you do?
Road is already started, Lord. If in this particular lane, road is stopped, Lord. They do not allow us to continue this. Both sides, road is completed, Lord. This particular portion, Lord.
In this
Why
regard,
will you allow without due process of law? Acquire this land. Can you make it khas and take this land?
then
And
it is
show us.
also
You-
not submitted the land which proof that the land is.
When will you they serve? When you issue a notice, the persons under this Dag and Patta, you are admitted case. This was this is they are having no document because it's a khas land. And how it has made khas? Because we want to make a road, make it khas. Very good.
Lordship, record may be called for whether their inception received the compensation or not, Lordship. Maybe, Lordship, in the year 1989, road was.
If
Maybe,
that is so, no.
Record, official record may be.
So
Yes,
is
sir.
this an affidavit? The petitioners claims that their private lands are sought to be taken away by the respondent authorities for construction of a road. Full stop. Construction of road. The respondents number 6 to, what is your name? What is your number?
4 to 6, 7.
Respondent numbers
4 to 7.
4 to 7. No. The state of Assam has taken a stand that the land is a land in question is khas sarkari land, and therefore the petitioners having no right title interest over the aforesaid land. In the aforesaid backdrop, this court, under its order dated 5/6/2023, directed the petitioner to file an affidavit, bringing additional affidavit to support of their contention, that they support of their contention in support of their title. Full stop. In the meantime, the respondent circle officer who has issued the notice has filed an affidavit and has taken a stand that the petitioners were owners and possessors of land mentioned in Dag number 49, 150, 155 under Patta number 1, comma, Dag number 149 of Patta number 09, comma, Dag number 151 of Patta number 42 and Dag number 152 of Patta number 44 under Niz Leverputa Part 1 Mauza. By inheritance. However, according to the circle officer and as disclosed in the affidavit, during the year 1988, 1989, under the direction of the Deputy Commissioner Kasar, under the order dated 4/9/1989 of the Deputy Commissioner Kasar, the land in question was made class for construction of road under MNP scheme. Full stop. However, no such communication is annexed with the record and annexed with the record, and there is no explanation as to how a patta land can be converted into a khas land for the purpose of construction of a land without acquiring the land under the without acquiring the land. Full stop. The Deputy Commissioner of Kasar District shall file an affidavit clarifying the aforesaid position and record clarifying the aforesaid position. Full stop. The Deputy Commissioner shall also clarify whether the predecessor in interest of the petitioners were paid any compensation for the land that has been converted into khas sarkari land for the purpose of construction of road. Full stop. When? Huh? 3 weeks you want this road construction to be stopped? Public,
Construction not.
and therefore you want that to be continued. People are suffering. You do want to stall the. Okay, list this matter on. After 2 weeks, give a date. 21st of March. Madam, communicate and be careful. This is not the way to handle citizens' right. Did you? I said it. Admission only. Admission complete kori to pursuant to this court's order dated or judgment and order dated no dated 8/2/2024, the registry has obtained the consent from letter commanded last no office note dated 22/2/2024 reflects that Honorable Mr. Justice Arup Kumar Goswami, Honorable Mr. Justice Arup Kumar Goswami has given consent to be an arbitrator to be the arbitrator in terms of this court's judgment and order dated so and so. Full stop. Accordingly, in view of that, Mr. Arup Kumar Goswami, Mr. Justice Arup Kumar Goswami, retired Chief Justice of so and so is appointed as the arbitrator.
I just want to give lordship permission, lordship, because lordship, in this case also lordship claim was more than 20%, and that is also agreed in the contract lordship, and this is the
File a review or go to Supreme Court. We have delivered a judgment, isn't it?
lordship.
It is today is the date fixed for acceptance.
That is subsequent development.
Then you file a review or whatsoever permissible. You cannot argue on us.
May I please look up? My lord, here two petitioners are there, my lord.
Hmm.
My lord, their houses and all properties were, my lord, damaged. My lord, reduced to ashes.
Yes, who will file the affidavit?
Deputy still, your lordship.
No, no, main role is of the inspector. Electricity inspector, isn't it?
Yes,
That is
yes.
a state's official.
Yes, yes.
Who will give the report?
My lord, the report has given by the fire and emergency.
Where is that report?
That is page 15, my
Page
15, 1-5. Fire and emergency service inspector, Karupetia, Lorong.
Oh, this is fire incident report by whom? No, no, there is a report is to be given by electrical inspector, something like that, isn't it?
That was
What is your prayer here?
on a here, my lord, for compensation.
Under what provision of law?
My lord, as per Assam Electricity Regulation Commission, my lord,
Then what is,
There is
who
a
will,
provision, my
how it is determined?
determines, my lord, there is specific mention, my lord, regarding damages of houses, my
Hmm,
full damages, my lord.
hmm. Who will determine these damages?
That will, my lord,
This court?
no, my lord, I am not, my lord, for determination, my lord. My lord, compensation, they paying for compensation, they made application, my lord, before the electricity board, before the circle officer.
Now tell us for payment of under what statutory provision or any executive instruction, it is provided that a person is entitled for compensation if there is an electrical accident.
Yes, ma'am. That is mentioned in Assam Electricity Regulation Commission 2019.
Now tell us what is that provision? Let us understand.
That is
First is to be, now let
Hello?
us, on the first twist, you'll have to say that this is my right under this is provision of law.
my lord, after the
What is your right under what provision?
after damage, my lord, they made an application.
No, no, you
Before that,
can make thousands application. I am not asking on facts. I am asking you, what is the provision under which you claim a compensation that this authority ABC is liable to give me compensation, or that I am entitled for compensation under this provision? Which is the provision?
No, that is mentioned in the regulation, my
Regulation, which provision of the
my
regulation?
lord, chapter 3, page 8.
Chapter 3, page 8.
Page 8.
Okay,
Liability for compensation.
okay.
Here, my lord, notwithstanding anything contained in any other law in force,
Hmm.
the licensee granting company shall be liable to pay compensation as specified in this regulation
Hmm.
to the person affected
Hmm.
or his dependents for loss of human life
Hmm.
or partial total disablement or loss of animal life or damage to property in consequence. Their property was
Hmm. Okay, now who will assess this compensation?
uh, assess, my lord, that is not specific. Who will assess the compensation?
Now
My lord,
come to
my lord,
the chapter 3 you have read. Come to the next clause. Clause 8.
assessment of compensation.
Then not given.
Quantum of compensation payable in respect of injury to a human being
Hmm.
or an animal or damage to property shall be assessed by the license. On a license, my lord, that's a petition.
Okay,
And they made a
that is what I am asking. Give me compensation. Who will assess this?
direct them to assess my.
We do not know whether they have assessed or not. They might have assessed in the
Not
meantime. Where is
assessed, my lord.
APDCL?
They made application, but
He
not
has not
assessed.
made APTCL party, but I am appearing for
Letter of-
AGCL, your lord.
Huh?
He has not made APTCL.
Okay,
Let-
distribution. What is your stand?
I'm for AGCL, your
What
lord.
is your stand?
Our stand is that no 132 kV line has been passed, the disciplinary line he has asked for, your lord. So this is the instruction.
No, answer his, answer his.
No line has been, it is written, your lordship.
No, no, there are two aspects. One is aspect not going at 132 kV line.
Yes.
Or having a damage due to electrical accident.
Yes.
Who will determine this?
That is by.
That is to be determined by the inspector, electricity inspector.
Yes,
And that is to be determined by the state, that is the
Yes.
employee of the state,
yes, your lordship.
is not it?
Yes.
Because an individual authority will determine that, then APGCL will assess, then it will be paid.
What is it? Inspector by state government.
What is that act under which that electricity inspector is appointed? Yes, what is that act, Mr. Council?
My lord, 2003 Act.
2003 Electricity Act. Learned counsel for the you file an affidavit, APGCL
Already
6
I have filed an affidavit.
Okay.
To my
six
lord,
for 2 weeks time to file an affidavit. Prayer is allowed. Full stop. List accordingly.
my lord, I have filed, my lord,
Your lordship, I will file on in this instruction only.
No, that's all. You file an affidavit, say that,
Yes, yes.
because we may grill you, because you have a right, you have a responsibility under the regulatory. We do not know why file. He has filed an application. You cannot come and say that this is done, this is not done. That is to be done by an assessment.
Yes.
He has brought on record by the fire that yes, this has been got damaged by the electricity accident. Now this may be an accident from his own mischief, or this may be a high power line. That is to be done by an assessment. Somebody will come and file an affidavit that it is so and so. On basis of what?
That electrical inspector's report is also reported.
Huh?
Inspector's report.
You make a stand there. And you have not made state of Assam a party. Electrical inspector made a party.
later on, my
Okay.
lord,
Okay.
No,
Huh?
no, your lordship, no.
later on, I
Let
have
me-
filed an IA, my lord.
Okay.
IA number
Okay.
1076.
Okay. Now we understand what we'll have to do from tomorrow. Yes. We'll have to take all the responsibilities onto us. Isn't it? Okay.
Apply.
Lordship, in this case, may I taking a adjournment for today, Lordship, can the Lordship, matter will be taken up tomorrow, Lordship.
Why?
Lordship, yesterday I called my learned friend to take a mention, Lordship, but he was not kind enough to make a mention. And today, tomorrow, Lordship, I will place all.
You are for whom?
I am for Lordship.
You are the villagers.
Pleasure.
You do not want 2 petrol pumps.
Yes. This is the case of matter,
Huh?
Lordship.
You do not want 2 petrol pumps. Why?
The new petrol pump, my lord, which is supposed to be set up, my lord, is within the restricted area.
Now, suppose it is within the restrictive, under what authority it cannot be permitted?
Well, there are rules, the Ministry of Road Transport.
That is rule or guideline?
Guideline.
Guideline issued under what provision?
Well, that is in its Supreme Court judgment, it will say that these are mandatory.
No, we are going the later on to the Supreme Court. We'll reach Supreme Court a little bit later. It's far away. Let us first understand what is the under what authority that guidelines are issued. You have answered Supreme Court. Supreme Court will go later on. I want to know under what authority these guidelines are issued.
But it's under the Road Transport Authority.
Road Transport Act.
No, my lord.
No, these are statutory guidelines or guidelines, executive instructions or guidelines issued under.
Guidelines, my lord. Guideline.
Okay, it is mandatory.
Mandatory.
Mandatory for whom?
Mandatory.
What is the purpose of this guideline that there should be a distance of 10 kilometers?
Probably, my lord, for taking precautionary measures, my lord.
Not probably.
It is.
What is the object? It may be object of protecting business interest. It may be with the protection of environmental pollution. It may be for any other purpose that we'll have to look into. Then only question of your right challenging construction will come into play. You have a right that mobile towers will have to be erected within only 10 kilometers because it creates a health havoc. If somebody does it, you have a right that yes, you cannot do it. This is my right. I have a right to health. What is your right and what has been violated?
The rules have been violated, my lord. Guidelines.
Look,
Guidelines.
what is your right for under the guidelines? Guidelines may be meant for a business purpose. Guideline may be meant for a different purpose.
These guidelines were set by the Ministry of Road Transport.
Guidelines are set by the ministry.
Yes.
For what purpose?
For regulating the setting up of.
Understand, then what is your right? There may be a business, its purpose should be a business regulation. Your right must be related to something, no? You want time?
Tomorrow or today, only today.
How can you expect that we'll adjourn it till tomorrow for your inconvenience or convenience?
Actually,
The learned counsel for the UFO,
I'm for 6 and 7.
as per number 6 and 7, press for an adjournment.
Lordship.
Prayer is allowed, least after a week.
Can it be on 26,
Why?
25 or 26?
Any urgency?
I don't-
Any urgency?
It's been pending.
Any stay?
There's
No.
no.
Construction is over.
Commission also.
Huh?
Already
Commission.
commission.
Okay, we'll take after.
One.
I have a judgment, Lordship. I have got it.
All are on judgment.
No, Lordship. That,
When do we need a judgment? When we are confused, we are not understanding, we need a leading light. Then only we need judgment.
obliged.
All are on judgment.
Obliged.
Yes. Item?
Lordship, the respondent is filed. They have not filed yet. As per
Yes,
the
yes,
earlier
yes.
order.
PWD. PWD or what?
Yes.
Simple question. Thor,
My lord,
contract is silent.
my lord.
Who will pay the GST?
My, my lord, this is Muslim Ali.
Yes.
My lord, we have sent exclusive affidavit for betting. It is coming, my lord.
It's there is no need of any affidavit.
In the contract itself, my lord. No, it is there, my lord. Who will pay? They have to pay, my lord, GST.
No, our question is, if there is no exclusive provision, their case is that there is no exclusive provision. Okay. When there is no exclusive provision, who will pay the GST? And on the basis of that, a contractor coach is rest. And now you are not paying the GST. That is your case, madam?
Yes.
That
lord.
is your case. Now, if you say that already there is a contract, then it's a 2 minutes order to dismiss. If you say there was no contract, but end user will have to pay it. End user is, you are the end user. That is the issue why we need a two-liner. Either there is a contract, this is the clause,
Well-
matter ends there. Or that
Page number 103.
page number
103, 41.1.
103.
This is the writ petition, my lord. 103, 41.1, my lord. Text, may I read, my lord? The text quoted by the contractor shall be deemed to be inclusive of sales tax, other levies, duties, royalties, etc., toll, taxes of central government, state government, local bodies, and
Yes,
authorities.
madam.
But GST is not mentioned.
Why not this is not-
My lord,
all-
we
all-
may not say GST, my lord, taxes. My lord,
All central and state government
taxes.
taxes of central government.
we may not say GST, but central government taxes we have mentioned, my lord.
Why you needed this kind of affidavit to be vetted?
My lord,
Mr. Dhar,
my lord.
who needs time now? Let us dictate this order.
No, Lordship.
That is your case.
Lordship, but I am appearing on behalf of Isaac, so order may pass by this. Otherwise,
So now adjournment is shifted to here.
if they file the affidavit, we'll file
Okay.
one reply.
There is no requirement of file. Your whole case is that
That is.
there is no
41.
clause in the tender for GST. Why should we waste time? We can dictate it that this is a misconcept. This is the, and that will include a CST. So all central taxes.
Actually, my friend was.
On the prayer of the learned counsel for the petitioner, matters stand adjourned and be listed on.
My lord, it is up to them. Oh, my lord, after 1 week, my lord now knows the case, my lord. I will partially. the affidavit.
Yes, give a date. 14th of March.
Lordship, this is typical challenge the order, Lordship, imping order page 34.
Affidavit file.
Lordship.
What is your stand?
And only they, at the time, they have not produced the relevant documents.
Mm,
They file a representation, it is the next 18 phase 26.
Mm.
It is under consideration, so this maybe dispose of representation annexer 18 phase 36.
What is that impugn order? 24 4
Page 34, sir.
page?
34.
Heard. Mr. L.R. Majumdar,
No.
learned counsel for the petitioner. And Mr. S.K. Medhi, learned central government counsel. The petitioner is aggrieved by an order dated 27/4/2020, by means of which, he was removed from the list of approved contractors under the respondents. Full stop. The impugn order reflects that the petitioner was asked to submit certain documents by 31st of August 2019, and he failed to submit such documents. Accordingly, the petitioners were removed from the approved list of contractors with immediate effect. Full stop. The impugn order further reflects that the petitioner was given an opportunity to file an representation against the order of removal to the CE within bracket AF Shillong zone with 1 month from the date of the impugn letter dated 27/4/2020. Full stop. Mr. Medhi, learned counsel appearing CGSE, submits that the pursuant to the said communication, the petitioner has preferred a representation on
It was 24/9 September. Some delays.
24/9
2020.
2021. Full stop. And same is under consideration of the CE within bracket AF Shillong zone. Shillong zone, though there are some delay in preferring such appeal. Full stop. Preferring such representation. And accordingly, he submits that the matter may be relegated to the authority to decide the representation of the petitioner. It's that in as much as petitioner has opted for the remedy prescribed in the impugn communication. Full stop. Mr. L.R. Majumdar, learned counsel for the petitioner, submits that he will have no grievance if the representation is considered on merit and disposed of. Full stop. In view of the aforesaid consensus, the petition is disposed of with the following direction. The CE within bracket AF Shillong zone shall decide. The petitioner shall intimate, furnish a copy of this order. The CE AF Shillong zone shall dispose of the representation preferred by petitioner dated
What it is 24/9/2020.
24/9/2020 and by a speaking order. Full stop. Such exercise be such exercise be carried out within a period of
2 months.
6 weeks from date of receipt of an copy of this order passed today by the CE AF, to be furnished by the petitioner. Full stop. Accordingly, with the aforesaid declarations, while parting with the record, it is made clear that the petitioner, this court has not has not entered into the merit of the claim, either of the petition.
Alright. I mean, respondent. My lord, your lordship kindly take his last two order, my lord.
Lordship,
Because my lord, if your lordship go to the last two order, my lord, everything will come out, my lord.
Lordship, we are newly engaged, so we have
Who
not
are you?
filed ex-Soikia.
May I submit, my lord?
We have not filed our wakalat number.
What affidavit? Where is the earlier order? Tell us.
Earlier order, your lordship kindly go to the, my lord, Honorable Justice, sorry, my lord, not name, peace base 97. This is the order.
Yes.
Started from 94, my lord, 11 part is 97, my lord. We are, I am giving the background of the case, my lord. One complaint has been filed against this cement company, my lord. For my lord, they have, my lord, acquired, my lord, tribal land of tribal belt and block, my lord, and also my land, my lord. Then on the basis of that complaint, they have stated that first round, they come before this honorable court, stated that
Now, what is the proceeding stage, the stage of the proceeding?
proceed nothing, my lord, because this case has been filed, my lord. So, my lord, nothing has been done, my lord. And my lord, they are asking for cadastral map, my lord. And circle officer say in their affidavit, the cadastral, it is not possible to give cadastral map. This is not the first step.
When, tomorrow?
Yes. Yes, tomorrow, Lordship. We have not filed our wakalanam also, so no instruction received. That is the thing.
If you are not filed your occult, we are dismissing for non-prosecution.
Lordship, time some time.
When are you filing that?
Today or day after?
Day after, list this matter on Thursday. As the learned counsel, MS S. Saikia submits that she has been engaged recently in this matter by the petitioner. First of all.
Lordship, the date may be.
My lord,
next
I
week,
have an
Lordship.
objection, my lord.
That's because we are.
You are
Because
asking, this
not
is an
from him, my lord.
absolute abuse of the process of this.
Yes,
court.
my lord. In order also stated.
Mr. Chaudhary, take your seat.
Sorry, sorry,
Lordship, did we have?
Why are you so excited?
sorry, sorry.
Don't be so excited.
Sorry, my lord.
When the court is in your favor, why should you open your mouth?
Sorry.
Yes.
Lordship, I have no instruction regarding, but we are just.
See. This is a tribal belt. There was an industry, there was a complaint. Different things were there, then repetition, then it was remanded back, and circle officer was asked to decide. Now you want some cadastral map, this, that. If no cadastral map is prepared, from where it will give? Let the deputy commissioner, let the circle officer decide on the basis of material by this order. And then why are you sitting over? Where is the stay? That you will not proceed. Madam Borua, you will have to be careful in this court. You will have to be careful. I'm telling you. And you have everything nowadays in your hand. You need not go to your file. You can click the green button and you know what was the orders passed. Everything is there. You cannot say I am not aware. And this nowadays, everything is recorded in the orders.
Lordship, on next week.
List this matter on Tuesday.
Back of the from Treasury.
Treasury will
Yes,
transfer.
okay.
So dispose it of.
Yes, my lord. Lordship, one respondent.
It's went to Treasury, will record it.
Lordship, and this instruction will be kept in record, Lord.
Yes. If it's reached Treasury, that it cannot return back. It will go to your account only.
Absolutely. But since February, 2 February, it's pending.
There
in
may be
before
there may
Treasury.
be some difficulty from on your part, client's part
Lordship.
also. Maybe some problem. Key question, obligation order. প্রথম paragraph থেকে চলিয়ে।
Lordship may kindly pick up this. Sorry.
Okay. The Standing Council Revenue and Disaster Management Department submits that the amount so sanctioned has also been transferred to the concerned treasury. First of, in view of the aforesaid, the contempt petition stands closed.
Lordship, make them direct to the treasury within a limit period, they will read it.
We are in a
Be-
contempt jurisdiction.
Because Lordship, if dispose of this contempt petition, they will keep pending again. That is the
Why
difficulty
this
here,
is
Lordship.
treasury is pending?
Because-
There is a-
Because Lordship, 2 February, it is pending. It's some,
This court expects that as sanction has already been, due sanction has already been granted, and the additional deputy commissioner has also submission has also been made on behalf of the additional deputy commissioner and CEO DDMA Kamrup, that money has already been transferred to the treasury, the concerned treasury officer shall release the amount at the earliest.
Lordship,
Contempt petition stands disposed of.
different.
Specific in the record, our
Huh?
instructions.
The instructions furnished are kept on record as marked as document X and Y.
Obliged.
If
Item 47, 48.
Yes. What is this, Mr. Das?
I'll just tell you,
Not
Lordship,
that
what
zero.
has really happened in this case. There are, just don't open, there are 4 points
Okay,
which we have taken in this particular case, 4 points.
Hmm.
First point is that an SOP has been issued
Hmm.
by the state government
okay.
in respect of 2 fights. One is buffalo fight
Hmm.
and one is bull fight.
Hmm.
And that is only restricted to a particular period, 15th of January to 25th of January, so far as buffalo fight is concerned.
Hmm.
Now, we have come up before this court by a writ court,
Hmm.
before writ petition.
Hmm.
Basically, on 4 points we have taken.
Hmm.
Point 1 is that SOP which has been issued is in violation of the Prevention of Cruelty of Animal Act 1960.
Okay.
That's number 1.
So
Number
you have
two-
basically challenged the SOP.
Right.
Hmm.
Number 2, we have taken also number 2 point.
Hmm.
Second point
Hmm.
is that in violation of the provision of the Constitution,
Okay.
because they have not taken, they have to amend the Prevention of Cruelty Act, Animal Act 1960.
Hmm.
It is in violation because you have, because there, it is a central legislation.
Hmm.
Now, it's a given the power to the state, if there is an act,
Hmm.
now they have to amend the act. If they have not amended the act, and it has to be with the assent of the President of India, which has not been taken. This is number 2.
Hmm.
Number 3, which we have taken is SOP is in direct conflict with the judgment of the Supreme Court. 2 judgments, A. Nagaraj.
Hmm.
After that, there's a constitution bench, 5 judges,
Hmm.
which I mean, it's in conflict.
Hmm.
And number 5, we said buffalo comes under the bovine species.
Hmm.
So, and such, it cannot be a performing animal. So these are the 4 points we have taken. And the matter was taken up by this court.
Hmm.
And an order has been passed
Hmm.
by this court, because what has happened?
Hmm.
Well, if you see the SOP,
Hmm.
kindly see the SOP for a moment. Page 42, kindly see the SOP of the state government SOP. Kindly see the writ petition 466 of 2024. There are 466 of 2024. And 466. no? There are 2 writ petition,
Why 2 writ petition?
because one is buffalo and one is SOP in a bull fight.
Okay.
So we categorize both 2 different writ petitions.
Okay.
kindly see-
fundamental
is
grounds
all
are
same.
okay.
Because here is the prevention of cruelty, that is Wildlife Protection Act,
Protection Act.
that's we have challenged. Bulbul.
Okay.
So kindly see 27th of December 2000.
Space.
Page 42.
Now, what is immediate? What is the
No, no,
immediate
no,
cause of
now what
action?
has happened? Yeah, I will not trouble because
No.
there is not question of deciding the issue. Why we have come up before this court?
Hmm.
Because there is an order which
Hmm.
has been passed by this honorable.
That we have
I'll
seen.
just, you all have seen the
Hmm.
last order.
So
The
it
last-
says that any additional material, interim order is kept open, any
Yeah.
additional material we can
Now
consider.
the problem is that
Hmm.
how many times we will come to the court and trouble?
Hmm.
Because we have seen after the order which was passed
Hmm.
by this court
Hmm.
in respect of one fight,
Hmm.
we immediately wrote to the authority.
Hmm.
Authority has stopped because SOP supports us,
Hmm.
saying that you can held only 15 to 25th of January. Beyond that, you cannot held it.
Hmm.
It's a government SOP.
Hmm.
So we said, please try to enforce this SOP. We told the government.
Okay.
We told the government,
Hmm.
please try to enforce it because it's your own SOP.
Hmm.
No doubt we have challenged the SOP. Presently, SOP
Okay,
is not
SOP is holding the field.
holding the field. Now, you cannot, no, other district cannot hold any those fights. How can they hold
Now,
the fight?
anything is proposed or being held?
Now, kindly see additional evidence.
Hmm.
Even after
Hmm.
the order
Hmm.
passed by this court at 244,
Hmm.
kindly see 244.
Affidavit.
Yes, 244. Just kindly see 244 of the order.
Hmm.
Just one paragraph, I'll read the order.
Hmm.
244 paragraph 8,
Hmm.
additional evidence. 244. Notwithstanding the challenge to a legality and validity of the impute notification SOP set of guidelines, Buffalo fight, which would need further examine, it is evident from the notification SOP set of guidelines that the state government itself has observed that no Buffalo fight would be permitted any other period other than 15th of January to 25th January in a calendar at any other place. Therefore, this court like to observe during the pendency of writ petition, state governments ensure strict compliance.
Okay.
Right?
Yes.
Even then,
So as
even
an
then,
example.
now I'll show you an example. Even then, they are at page 246. Kindly see 246.
246. This is guideline.
No, this is an FIR. After the order passed by this court,
Hmm.
even certain other district they are allowing to hold. This is an FIR which we filed
Hmm.
on 21 to 2024. Complaint seeking register FIR against the organizer, participant, animal owners against the conduct of illegality paragraph with video photography. Now against this, my lord, they have registered a case at page 250. Kindly see 250.
Hmm.
Kindly see 250. They registered a case. Otherwise, they would not have registered a case.
Hmm.
They have registered a case on 21 to 2024.
Hmm.
This complaint is on 21 to 2024.
What was the order earlier order dated?
Earlier order is 6th of February 2024.
6th of,
February 2024.
and this was held on
21st.
Hmm.
21st of February 2024. Another incident which has happened, kindly see at page 251. Kindly see 251.
Hmm.
251. This is 22nd of February 2024. This is another complaint which has been filed and which is going to held, but in this period,
Now,
already it is.
Mr. Just tell me what the SOP, what is the SOP says that if there is a violation of the SOP, what is the
Yes,
anything?
yes. 43 kindly be seen.
Please.
There is here what normally happens, my lord.
Hmm.
My lord, what happened
No,
normally?
we want to just suppose we pass
No.
and stay order
Yes.
today. We want anything we do, it must be
That-
complied with at any rate. So we do not want to pass an order which is non-implementable. Now, therefore,
What I
our
propose-
specific
what I
query is what is the remedy when
Remedy-
this SOP is violated?
There is a penal provision. Under this statute, under PC Act also, IPC also, there is a penal provision. What your lordship will do is, I propose,
Hmm.
not on the basis of this additional evidence.
Hmm.
Your lordship's power is wide power under 226, unlike 32 and 136. Your lordship has much more wider power. That's what the apex court is saying, that the high court has got more power than us, than 32 or 1
Yes.
or 136. They, my lord, with great respect, under 142 the powers have been given, so that become the law of the land. But what I propose, my lord, additional affidavit we bring notice to the court because of passing an interim order. If
No,
at all.
suppose, no, that is not an issue.
Yes.
That you file an application.
Yes,
The concern of this court is, suppose we pass an order
yes,
today. Already a guideline is holding the field.
yes.
Suppose we pass an order, already same thing will be, same thing, we are restraining. There is already restraint that
No,
you cannot do beyond this.
I'm sorry.
Now,
No,
against whom will you pass
No,
this
no, no.
order?
What is it? There is, the problem here, there is no blanket stay. There is an order, if
Mm.
your lordship kindly read the order
Mm.
of the last court,
Mm.
6th of February 2024,
Mm.
paragraph 8. It says whenever it occurs,
Mm.
please do come to the court and inform to us.
Mm.
Now, it is beyond our control. There are,
No,
if
we
I'm not
understand, we
wrong,
understand.
36 districts, 36 if I'm not wrong,
Mm.
36 districts. Each and every district is very difficult to control. Now, we come later on. Our organizer comes later on at the point when it is.
No, understand.
This is
That
the
is
problem.
same problem this court is thinking
That
of.
is why, that's
That
why.
will pass an order, we'll pass an order here, we'll pass an order, then everybody
No,
will
your
do it,
lordship-
file a contempt. There are same
No,
thing
no,
you
what-
prosecute in a
No, no,
criminal
what
law.
I said. My lord, if you.
If there is an
No, if your lordship-
proposal that it will be held on 31st of March, we may stay.
No, no, no. My lord, it is the duty of the state government.
That's why.
That's why I'm saying their lordship will have to give a direction state government. They strictly compliance with the SOP. But they are not complying. With great respect.
No,
and
that we
pride,
understand.
what they can do it, my lord, I will not give advice. They will inform to all the districts that this is what the deputy commissioner will keep on vigilant. The SP will keep it on
In
vigilant.
fact, if you go to the order passed earlier,
Yes,
court has, this is not less than a stay.
yes,
This is what the court has observed. Court
Yes.
says that it is the responsibility of the state to implement the SOP.
yes, 244.
How to, if any information, this is written. Therefore, this court likes to observe that during participation, the state government shall ensure strict compliance.
Right.
There is a direction.
But even after that, who has to look into it? The
Now,
state government.
what is the remedy then?
Remedy
That's why I
is-
have asked that question.
One, the remedy is that your lordship will give a direction to the state government. If any violation occurs, if in pursuant to SOP, then my lord, they have to face the contempt. The appropriate deputy. the
No, this
appropriate
is a
district-
specific direction. Bring anything on notice,
Yes,
we'll
we
draw a
have brought-
contempt
So we
after
have
this.
We have brought notice to the court. Your lordship will take.
No, that is 6th of March, 6th of
February.
February. Then all this happened around 11 to 16 and 21st of February.
Yes.
Isn't it? So therefore, this order might not, okay, we are giving a leeway that 6th it was passed. But this, Mr. There is a specific order. Anything happened hereafter.
It has to be brought to the notice of the court because there is already.
But you circulate this order.
We have, that SOP is there.
You circulate this
That's why I
order.
didn't want to say, like 41A, your lordship knows that judgment
Mm.
of 41A has been circulated. High Court has circulated to all the lower courts.
Heard Mr. D. Das, Learned Senior Counsel, assisted by DJ Das, Learned Counsel, and Mr. Talukdar, BJ Talukdar, Learned Senior Counsel, assisted by Swenson. The petitioners herein has assailed a notification dated 27/12/2023 issued by the state of Assam in political aid department, whereby a standard operating procedure within bracket SOP was issued prescribing certain guidelines for buffalo fight both orders will pass common order, huh? And Bulbul fight. Okay. The such challenge, the basic ground of challenge is that the notification SOP was issued in clear violation of the provisions of Prevention of Cruelty to the Animals Act 1960 and what that is, Wildlife Protection Act, comma, full stop. The further ground is that the said SOP has been issued without any amendment to the Prevention of Cruelty Act 1960 and without the assent of the President under Article 254 of the Constitution of India. Full stop. This court, under its order dated 6/2/2024, observed that during the pendency of this writ petition, the state government shall ensure strict compliance of the notification / SOP in respect of buffalo fight and and this other also, Bulbuli also, same order in Bulbuli, Bulbul fight.
Without prejudice to the notifier.
Fight, in as much as it was an observation by this court that till the legality and
Yes,
validity of the SOP is determined, the said SOP shall hold the field. Full stop. Full stop. And if hold the file. While passing the interim order, this court also observed that the interim relief shall be considered at appropriate time when the petitioner brings notice of this court any incident of violation of the SOP. Full stop. The petitioner, by filing an affidavit on the opposition, has brought
Additional
on
affidavit.
additional affidavit, brought on certain facts to suggest that even after order of this court dated 6/2/2024, buffalo fights and bulbul fights,
Not Bulbul, only buffalo.
buffalo fights are being still carried on, and the district and the state authorities are not taking any appropriate measure in this regard. In the additional affidavit, as many as how many affairs? Two affairs has been annexed to suggest that the petitioner has acted against such activities. Full stop. Be that as it may, as this court has already passed an order observing that during the pendency of this writ petition, the state government shall ensure compliance of the notification, etc. This court thinks that a direction should be issued to the state authorities to notify and intimate through the district administration regarding passing of this order dated 6/2/2024 with a further direction to ensure strict compliance of the SOP. Full stop. Full stop. Anything to be done today or we can decide it?
If there is a violation, then automatically it will.
We will not say anything, definitely it's a direction.
We'll
We
come up with an
cannot do things on apprehension.
We'll come up with an application.
Okay, now when to affidavit file?
No, they are not filing.
At this stage, the Learned State Council submits that they may be granted 2 weeks time,
2 weeks.
2 weeks time
2 weeks.
to file affidavit. That's legal issues.
Yeah, legal.
No
2
affidavit is required in
weeks.
fact.
2 weeks time. It will be
2 weeks time to file affidavit, 3 weeks time to file an affidavit.
Because although it's legal issue, my lord, the issue is there two Supreme Court judgments.
That's
But
right.
in other states, my lord, they have amended the post. And it is concurrent list, have NP-17 of concurrent list. So the state has passed some.
Anyway, we'll just test the legality. If you can satisfy that whatever you have done is correct, fine.
this state has done it. This state has done it with the assent of President of India. One is Tamil Nadu, Karnataka and Maharashtra has done it. But you have to look into it, whether there is a violation of these two acts or not. Because those are races.
So therefore, these are the basically legal issues. We'll have to see the SOP and a legal provision, isn't it?
Correct, correct.
And those rules were upheld by the Supreme Court. The
Okay, fine.
subsequent court.
You,
Yes.
that is a legal issue.
Mine.
That
Yes.
need, some officer need not say that this has been issued.
Mine.
3 weeks, list this matter on.
First of April. Few weeks. First of April. The rule of- First of April.
1st of April.
Quickly. Item 4.
Yes,
Here, my lord, the petitioner is the contractor under PWD
Mm.
department. In the year 2015, a devastating.
we understand everything. Now they say that you are not a contractor, you have not executed. What can this court do? Tell us that. We understand your story, we understand their story. also.
Well,
Now tell us under these circumstances, what order can we pass? They say he is not a contractor, he has never executed work. What Reed Court can do?
But my lord, page 22, there is a joint verification report of
They
respondent.
said nothing, this verification was not even done.
They said the work has been done.
No,
But
no.
who has done, that is not it.
So can we decide? Kindly come to page 46. Paragraph 9 and paragraph 10. Read it. Page 46 of the affidavit, paragraph 9 and 10.
Yes,
Read it.
that with regard to the statement made in paragraph 9. So that of the writ petition, the answering deponent does not admit anything which are contrary to and
You start from the answering deponent, next 2 lines.
the answering deponent further begs to state that joint verification was done, but there was no report regarding the work executed.
Okay, now come to paragraph.
10.
Then go to the last paragraph. It was informed by the engineer PW Dhibri, Rural Road Division, that. Read.
My lord, paragraph.
Page 47, first line. Or should I read for you? Dhubri that no work was done on verbal order at Bilasipara Rural Road Subdivision as mentioned by the petitioner.
My lord,
Now read it. Further, begs to state that the petitioner has not executed the work. Therefore, the question of regularizing of work or release of fund does not arise.
the step actually is also taken. Can it be after a week?
No, we are deciding right now. Hard.
Then my lord, say for appropriate.
What for approval? Dismissing this. That this cannot.
With liberty to approach the if it can
You
approach.
can go to civil court, no problem on that. You will have to establish that it was the verbal work. Therefore, that you need evidence. Hard. The learned counsel for the petitioner also none appears for the respondent step. The present application is filed with a prayer to release the outstanding due to the petitioner for execution of certain works. Full stop. According to the petitioner executed certain works under SDRF scheme for the year 2015-16. However, such works were executed on verbal request of the respondent authorities without any work order. It is the further case of the petitioner that a joint verification was subsequently done. Verification was subsequently done. However, even after that, the amount due to the petitioner has not been made. The respondent number 6, that is the executive engineer, PWD, Dhubri Rural Road Division, has filed an affidavit in opposition and had taken a stand that a joint verification was done as regards certain works, but there was no report regarding the work executed by the petitioner. Full stop. and further stand was taken that no work was done by the petitioner on any verbal order, and that the petitioner, and therefore there is no question of regularizing the work or release of fund. Full stop. In view, thus the respondent authorities has disputed the claim of the petitioner that he had executed such work. Full stop. Therefore, this court, in the aforesaid backdrop of pleading, cannot entertain this writ petition to determine the disputed questions of fact, that is, whether the petitioner has executed the work, and if executed the work. Accordingly, this writ petition stands dismissed. However, while parting with the record, it is provided that the petitioner shall be at liberty to approach appropriate forum to establish his claim. Full stop. Yes,
on.
next case.
I have taken the instruction, Lordship.
Uh,
On 29/2/2024, joint verification was done, Lordship.
Okay.
But it could not be completed. Lordship.
Okay, when will you,
Yes.
how are you proposing?
After 3 weeks, within 3 weeks, Lordship.
Okay. Learned counsel for the KASC submits that a joint verification was done on
29/2/2024,
29 to 20
along with the officers of APGC.
2024,
Four.
along with the officials of
AP.
APGCL. Full stop. However, the verification, joint verification was incomplete, and the joint verification can be completed within next 3 weeks. Full stop. In view of such submission, let this matter be listed after 3 weeks and on 28th of March 2024. Full stop. On the next date fixed, the learned counsel for the KASC and APGCL shall apprise this court as regard the status of verification. Status of verification.
Obliged.
Wait, please, Your Lord. Actually,
Yes.
this part, Lordship, against the inaction, Lordship, on part of the Testu municipality board. Take action, Lordship, against the unauthorized construction carried out by private respondent. Lordship. We have made several.
Representing the Tezpur Municipal Board.
Despite
No one is-
service of notice, they have not appeared before this court. Lordship.
Is it an elected body?
Yes, madam.
Notice served. Now what to do? You have filed affidavit.
Yes, my lord. I filed affidavit, my lord. I have constructed on my own land, my lord. And already, my lord, because of the disturbance created by the petitioner, my lord, we have also filed a civil suit, my lord, seeking injunction, my lord. So that is pending, my lord. So I don't think, my lord, anything remains.
What is your grievance? Tell us.
My lord, against that illegal construction, that we have first made a complaint, Lordship, on 8/12/2000.
Where is that?
Annexure 1, page 14, Lordship, your translated copy.
Annexure 1, page
Page 14, Lord.
14.
Lord. And there's another on 16/12, Lordship, that is annexure to page 16.
What is the role of a deputy commissioner in a elected municipal board?
You also find complaint as well as because not taken into account.
But your complaint all your complaint, no, not specific. What is the violation? What is not?
We have mentioned this a lot, but they have not taken.
See, on the first application, you say that তেজপুর পৌরসভা ইতিমধ্যে ব্যবস্থা গ্রহণ করেছে. This is your first, isn't it? Then why should we compel Tezpur Municipal Board? Your only grievance is that this officer, Hemen Potongia, he has not accepted. These two are the grievances.
But my lord,
There is no allegation against the municipal board.
but they have not taken permission, lordship.
No, they have not taken permission, but you have said that Tezpur Municipal ইতিমধ্যে ব্যবস্থা গ্রহণ করেছে. Isn't it? You say that that this building was without permission and Tezpur Municipal Board has already taken action. Your other grievance is that if RCC building is constructed, we'll have our problem, our house is a some type house. So you file a suit, they are filing a suit. You file a suit and right of
The suit
It's
also
not-
they can file counterclaim, my lord. They have-
Yes.
In the suit, lordship, we have filed our written statement
Mm.
already, but in the pro forma defendants, that is the municipality board, they have filed their.
in this kind of vague thing, it's difficult.
They have filed their lordship a written statement in which they have categorically stated that they have not given permission for a construction work.
Who?
Municipality board, sir,
Very good. File a counterclaim for demolition. Matter ends there.
lordship.
Now, what kind of order are you expecting here?
But my lord, as per the municipal act, lordship, they have to take action under section one.
If we go by the municipal act, then there is a provision of appellate authority. Even a permission is, this court has held that the grant of permission of non-grant of permission is also an action which can be challenged in the appellate authority. Yes. Deputy Commissioner. Sometimes you are very active. The deputy commissioners are sometimes very active. But when it comes to taking away land of the people, isn't it? Converting to khas land without going to land acquisition, you will take over land. But when people are coming to you, that nothing is being done.
And my lord, it's not a case that we have applied for permission, my lord, we have deposited the fees, my lord.
Hmm.
And they have
So
not,
dim,
my lord, deemed to be, my lord,
but there is a problem in dim.
my lord.
Dim cannot be beyond the mandate of the rules.
My lord, that is the, my lord, that's why.
Priyanka State,
My lord.
isn't it?
In the affidavit, my lord, we have categorically stated that, my lord, we have constructed this house on our own land, but both are brothers, my lord, neighbors. And his problem is that, my lord, because of the dust, my lord, of the construction, my lord, he's having problem, my lord. It started creating, my lord.
Both are brothers.
Yes, my lord.
He has become rich, you are poor. That is the issue. Yes, what to do? Tell us.
Suit is already pending, my lord, but his allegation is that, my lord, we have not. Because
But at one thing we cannot be oblivious that when an application is filed alleging that there is a violation, at least there is a provision for hearing both the parties. If the board is not taking up that matter, but what will they do? Where is your application before the Tezpur? These two.
Lord.
How can they take on this? What will they decide?
Lord.
Nothing is there.
Then I will file fresh for.
You will withdraw this. Anything will make a comment that will create a problem for you in your suit.
it can be both ways, my lord.
Both
It
ways.
can be both ways.
Anything we make a
my
comment.
lord.
Or do you advise what should be your
In the-
course of
In
action
the suit also,
from this court?
in the suit also I have made municipal board party, my lord.
And municipal board taken a stand that there is no permission.
My lord.
So very good for them to file a counter
Let
claim.
them to contest the suit, my lord. If there is any violation, my lord, then we'll come up.
Yes,
with
yes,
evidence.
what you,
With your lord.
oh, that is the problem. Don't leave to us. This is your case. We will dismiss it that there is nothing to be taken note of. by the municipal board. There is no specific complaint.
Then Lordship, I will file a case complaint, Lordship, for the municipality court. Lordship.
Okay,
Then we can file anytime.
okay, learned counsel for the petitioner submits that he may be allowed to withdraw this present writ petition and file a complaint before the Tezpur Municipal Board raising his grievances in terms of raising his grievances as regards the construction that has been carried out by the respondent number 6. Respondent number 6. Inasmuch as the complaint already filed lacks detail, complaint already filed before the municipal board lacks details of his grievances. Full stop. At this stage, Mr. Sundi, learned counsel for the respondent number 6, submits that due to the disturbance, due to the claim of the the respondent 6 has already instituted a suit seeking declaration,
Injunction.
the declaration of right title, interest and injunction against the present petitioners, which is pending before the
Court of
court, which is pending before a competent court in Tezpur. And the petitioner has also filed their written statement. Therefore, the matter can be decided in the suit itself. Full stop. Without entering into the merit of the claim, this court is of the view that as the petitioner wants to withdraw this petition and to approach the municipal authority against the construction that has been carried out by the petitioner, such liberty is granted, and accordingly this writ petition stands closed on withdrawal with a liberty to approach the municipal board. Full stop. While parting with the record, it is made clear that this court has not commented anything on the rights of the petitioner and the respondent number 6. In the event such application is filed, or not necessary.
Obliged.
May please, your Lordship.
Item? Yes.
Okay, I appear for respondent number 3, Lord. They were appearing for the first time, so we may be allowed some time to file.
What is the period?
My lord, the period, my lord, here, the petitioner has already been removed from his.
No. What was the period?
But
Is it not? It must be for 3 years, 5 years.
yes.
What was the period?
Lordship, that is until the general council comes into
No, my lord, the interim council is still open.
that has
The
to
interim council still operate.
still operate. Election has to be conducted, that which was not done as.
My lord, if as of today, if you go by what the order has become instructionless.
Why?
My lord, this affidavit filed by
Where is the impugn order? Where is the impugn order? Impugn order.
in order last page, my lord. Last page of page 39.
Page
39, my lord.
39.
Yes, my lord.
Yes.
My lord, here the writ petitioner was removed. Gamburu Musari was removed from the post of. There are allegations, my lord. So he was removed as the interim, and another person was brought in, my lord. So now, subsequent to this, my lord, what happened on 28th July 23? Again, the new person, he has also been removed by the government.
Hmm.
So, my lord, this order has to be challenged now.
Now interim general council may select new chairman.
They selected one, and again.
Now who want to file affidavit?
Lordship, the council itself.
Okay, file it.
File it, my lord. Where is
The learned counsel for the respondent number
3.
3. Press for and is granted 3 weeks time to file affidavit in opposition. List accordingly.
my lord.
Obliged.
Okay.
Yes, Mr. Ali.
Praise the Lord.
What is your case?
My lord, in view of the affidavit filed by the government, my lord.
Hmm.
Matter may be closed, my lord, because they have admitted, my lord, regarding shifting of the center.
Center is in the present place in. not
No,
shifted.
their
Our-
case is
our
that
case, my
village,
lord,
village
Yes.
was
Eroded.
eroded due to flood and something like that.
Yes.
So it was shifted.
Shifted.
Now there was a direction passed by the CDPO saying something
That-
that
Is
this,
there shifted to again, my lord,
uh,
the original place, which is not
But
in
it
it.
is
now,
not-
what is their standing
Now
affidavit?
they have taken stand, my lord, that they have ordered, my lord, on
It is on
page 16,
the new.
page
Yes.
16, page 16. my
Page 16 of affidavit.
No, page 16 of the repetition, my lord.
That order is remains.
Now the center is, my lord, is functioning as per this order.
Heard, Mr. Where is that paragraph?
Paragraph, my lord.
Paragraph 8, page 37.
Hmm? Page,
Page 37, paragraph 8.
paragraph
8 of our.
8,
affidavit. Other order paper. Then I mean here something.
Okay, the present writ petition is filed assailing an order dated 13/10/2022, isn't it?
No, my lord, 1310 is in our favor.
No, where is that order?
Page 16.
Page 16. Hmm.
Who are
Assailing an order dated
9/1/2013.
9,
9/1, my lord, impugn order.
Imping order is 9/1, but the order dated 13/10/22.
where is that 1991 order?
Page 29.
Page?
29.
Who are you?
I am the implemented respondent number 5.
What is
I
your
am
role?
against shifting lot.
Who are you?
I am earlier managing committee, president of the earlier managing committee.
You want to have, according to you, there is no erosion by flood.
But partly eroded.
So you want to have it in the bank of the erosion
Yes.
with the children. Okay.
No, Lord, actually what happened, Lord? The Anganabadi Center initially.
Now let us not hear all these stories because government has taken a decision against it. Challenge it. Order dated 9/1/2023. Whereby Islampur Sukhorzar, page 29, huh? Islampur Sukhorzar Anganbadi Center number 229 was directed to be whereby an order dated 13/10/2022 whereby a direction of shifting of the said Anganbadi center was cancelled. Full stop. By the order dated 13/10/2022, page
16.
16, 13/10/2022. A direction was issued to Randa Anganwadi Center from a different place by shifting the same in view of the background fact that the village for which the Anganwadi Center was created was eroded by flood. Okay?
By river Brahmaputra.
By river Brahmaputra, eroded by river Brahmaputra. Subsequently, said, no, what did you call it? 1310. However, the respondent authorities has filed an affidavit in this proceeding and has taken a stand that as per circle officer's report, the center is allowed to run in the present place at village Sukhuarzar in the public interest as per order dated 13/10/2022. Thus, by implication, the impugn order has not been given effect to. And effect to, and the public interest demands to continue with the with the Anganwadi center at the place in terms of order dated 13/10/2022. In view of the aforesaid, nothing survives to be decided in the petition. Accordingly, the same stands closed. Okay? Same stands closed.
A pleasure, lordship. Last order record was job. The practice is, my lord, land of kitchenage acquired for construction of Horsodai Stadium in 2003 itself. Thereafter, they have not received any another compensation. Rather, it was a decision earlier to set the petitions to file, my lord. Then it was decided to land, alternative land. But that was been not given to first. The record was.
Required notice.
You have taken land, you are not giving affidavits are being filed. Let us decide.
Record, for
Record.
record.
Okay.
Yes.
When? Tell us.
2 weeks.
Order was passed on 2/11,
2/11.
giving you 4 weeks time. That is 6/12.
Yes.
Now, after 6/12, this was not really even listed, though there was a fixed date.
That it was coming.
Huh? And this has been listed today.
As a last chance.
Last chance when?
2 weeks. Required.
Weeks. MS Borua Learned State Council submits that C may be granted further 2 weeks time to produce the records pertaining to LA case number 3/22/2003 in terms of this court's order dated 20/11/2023. Prayer is allowed. List this matter on 21st of March.
That should be word last son. Some force will
They
come.
know.
No.
We need not use the words. They will know. We may ask the person to be at 2 in the court itself.
Of course. Oblige it.
Then they will come, no? At the madam.
Hey,
Yes, Lordship.
Should we pass last chance? No, because
Yes.
we'll tell that it was a last chance at 11:30 or 12:30 and call him at 2 with the file. Isn't it?
I will bring.
okay.
Yes, next case.
33, in this matter, Dinath will appear, Lordship. He is like in court number 1. Kindly pass over the matter for time.
My lord, here is my last order, my lord. Last order, my lord. Order the 10/1 NHA, National Highway Authorities.
Here, my lord, I have filed another hearing here. Which wrongly impeded National Highway Authority of India, which have clearly said that the particular route was not affected by us. That information not so much.
Okay.
Regarding this, I already filed this. I also.
And PWD, which for PWD? Not.
Dinath.
Okay. We'll waiting for something.
Fine. For my lord, my land was identified and requisitioned for the purpose of construction of the deputy commissioner's office itself, without processing the acquisition. Now, after we filed the writ petition, my lord, they said that the proposal has been sent to the ZAD department.
For acquisition.
My lord, the ZAD we have implemented on 24th of January, my lord, the order has come. My learned
Our
friend,
name has not
he
been reflected in the costly document and we have not got any copy of the.
Okay.
Therefore,
Give a copy.
My lord,
Okay. The Learned Standing Council for the GAD submits that he may be granted some time to either to file affidavit or to apprise this court. Apprise this court as regards stand of the respondent number 2 and 3 to the effect that case of the petitioners are under consideration, and if the if the claim of the petitioners are found,
The proposal, my lord, as per the deputy commissioner's office,
okay,
proposal for financial approval as well. The rest is clear.
okay, okay, submit, he shall obtain instruction or file an affidavit as regard status of payment of land acquisition compensation to the petition. First up, when,
Lordship, after 2 weeks, sir.
list this matter after 2 weeks.
Keep clear.
Lordship,
In the, give a copy.
My lord,
Lordship, registry to reflect our name,
Okay,
SETAD.
registry to list this, registry to reflect name of standing council GAD in the cause list.
DPO.
Give a copy, I will not
My
pass
lord.
it. Yes,
My lord, last year, my instruction was short form from the government, my lord. And my lord, here my matter, my lord, is that, my lord, the petitioner number 1 wants to sell her plot of land to petitioner number 2. But
Hmm.
permission is not granted on the ground that there is a civil suit pending.
Hmm.
The petitioner actually one is the owner of a plot of land.
Your case is that my plot is different, suit is different.
Yes, yes,
So there is no bar in granting
permission.
permission. Now, who will determine this? They say that this can be decided under that Right to Public Services Act.
Yes.
Huh? So,
And as per my lord,
where is that right to public, which provision?
another is my lord,
Land sale transfer can be applied online. Only the person whose names are in the SITA can. Now, have you filed anything before the,
yes, we have filed a representation.
huh?
We have filed 2 representations
Before?
before the circular as well as the deputy commissioner.
Now, they will say that suit is pending. How can you decide?
No matter that.
What
They are
is the
doing nothing, madam.
procedure?
Actually, they may take a hearing.
Hmm.
They may take a, because the property in which there is injunction, the schedule of the land is mentioned in the state suit. So,
Who is for the private respondent? Is he made a party?
private
See, solo, ne?
private
Private respondent.
not my part. Not my part.
Is it not necessary?
Well, actually, madam, here, this land is completely different. Ma'am.
No, I understand. That is your case.
That is why we have not.
That is your case. But permission is not being granted by the authority admittedly for the reason that according to them, it is a subject matter of the suit.
An objection has been filed
Hmm.
by the daughter of the petitioner number 1.
Uh,
In respect to the all the land.
no,
entire land.
understand.
Yes.
Therefore, they are not giving permission on the basis of a complaint filed by somebody. You are coming to this court and saying that this is bad. They are saying that this is a complaint.
They are saying nothing.
No, they are saying nothing, but you know that there is a complaint. Now, is it not necessary for that lady or gents to be in the party?
No, madam, here, madam, our case, is, madam, let them give a hearing, madam. Let them give a hearing. And after that, they will decide, madam. Let them hear the matter. Let them call the other party, madam. And give a hearing. Then everything will be.
Yes,
clear, madam.
state.
Yes, on the last occasion also, we have been asked to take instruction as regard the status of this application which is
Mm.
pending.
Mm.
So we have communicated, we are yet to have a specific instruction as to whether it is pending or what is the status. So can it be taken next week or any day later so that we can come up with, this is relating to district Kamrup Guwahati only.
Okay, next week. Give a date on next week. The learned council, state council prays for and is granted. No, list this matter on, give a date. 14th of March 2024 to enable the learned state council to obtain instruction in terms of this court's order dated 19 to 2024.
Right.
Okay, we'll then, if nobody will,
They can.
we want that whether if you have not disposed it of, take this matter here, both the side, any object or anybody
The hearing.
in terms of this act.
Act.
The following the procedure laid down and prescription given in that act.
Yep.
That's all. Yes, Mr. Day.
They were supposed to file affidavit, you know.
Lordship, I appear for the response on behalf of Mr. S. Gupta. Lordship, we have received the revised comments. Lordship, 2 weeks time may be granted to file affidavit.
There is an interim order.
Yes, Smith.
Okay, learned counsel for the railways.
Hello,
Press for and is granted
2 weeks time.
2 weeks time to file affidavit in opposition. The interim order passed earlier shall continue. List accordingly.
Hello.
The affidavit of response submitted.
Uh, who will file affidavit?
The revenue department has to file the affidavit.
There is an interim order.
My lord, I have filed two IAs, my lord, in this case.
For implement. Who are you?
For improvement and other is for vacating the interim.
First, vacating will come later on.
Yes, my lord, improvement. is the
Subject
first.
to, we are allowing to be part of it.
Notices have not been issued in the.
This is the
Therefore-
first time, my lord.
Okay, we are issuing a notice. Okay, give the IA. Are you objecting?
I would be
Okay.
objecting because
IA, which was the,
there is no statement in the affidavit saying that the rate cannot be decided without the applicant's space. The very basis is not set.
My
is
lord,
just-
it is
okay, I will not go to that, you file an
only on
objection.
the basis of the
Who,
complaint,
who are you?
only on the basis of the complaint made by me as along with the other co-villagers. This inquiry took place and
Who is occupying what? He is occupying?
occupying the land of the market, my lord, which has been allotted to the government market, my lord, weekly market. That market they have encroached, my lord.
Okay.
And my lord, evictions took place only on the basis of
Order
our
says-
complaint, my
Order
lord.
says otherwise, my land was converted without notice to me, and when I asked what is the
That
case
is-
number,
Okay, let us, let
let
us
the
get,
government come up with it.
let them implement.
See, I would be objecting.
Better for you to get it decided. What is there, then we will know it. Hard, Mr. Mozumdar Lanet, hard MS SB Chaudhuri Lanet Council for the petition. This is an application for impleading the applicant as party respondent in the connected writ petition. Issue notice, okay, you file an objection. Yes, government, when can you file affidavit?
3 weeks.
Okay, returnable after 3 weeks. In the meantime, the learned, in the meantime, there is the opposite parties that writ petitioners can file objection to this petition. It will implement. Then in the main writ petition, the learned state council press for and is granted 3 weeks time to file affidavit in opposition. Full stop. List accordingly, interim order pass earlier shall continue till the next date of listing.
Here, my instructions are waited otherwise. But the issue involved is in the spirit of a PIL, not in the formality.
I have seen that, but spirit of a PI, let us, Mr. D. Gogoi, learned counsel, means that he is awaiting instruction. Accordingly, press for an adjournment. Prayer is allowed. List this matter. When? Any urgency?
No.
Any construction stop, anything?
No, already completed, my lord. There, according to them, it has not been properly repaired.
Okay, okay,
And for respondent number 5, the contact.
okay. Article List this matter after 3 weeks to enable Mr. Gogoi to complete his instruction and to file affidavit if so advised.
Okay, my.
But in that case, my lord, the state needs to have filed their affidavit, my lord. but for
39.
9 matter.
Here also, our inspections are awaited. In fact, they're having the protection from the court. This is with regard to an eviction notice which has been issued on 13/2/2023. So prior to that, there is a revenue board order which says that they are authorized. in
Let
eviction.
this stay, these are all 18-2 and 18-3.
Yes.
Let this stay remain for some time. There is a special division bench constituted. And I would not like to express any opinion right now because I am part of the division bench. two views are there, more particularly 18.2, whether notice is required or not required. So a special, on a reference, special DB is constituted. So already those stays are there. Let us wait for, we have fixed a date. Okay. Learned State Council press, State Council press for and is granted 3 weeks time to file affidavit in opposition. First up. List accordingly, interim order pass earlier shall continue till the next date of listing. Why we have adjourned it? D not. Huh? Wait. Okay, we are fixing next week. It is submitted that Mr. D Nath Learned Council is having some, he's busy in another court. Accordingly, matter stands adjourned and be listed on 7th of March, 2024. Full stop. 2024. Yes, there is a hearing matter, isn't it? Mr. Fukan, we'll be in the midst of hearing now, part third matter. We do not know how much time it takes. Who is for the parties, contesting parties? You can take a chance, but difficult. We'll complete this.
There are actually 3 matters. One matter has been transferred in the 2 writ petitions, which one I'm filing and one Swami is appearing. In that, pleadings are not complete. However, it's come in the hearing list. So in that 2 matters, anyway, the pleadings has to be complete. I don't know what the stand of the government would be. In the other matter, I think Mr. Das is leading us in, where I am a respondent also. That pleadings are complete. So that is where he is a petition. So either your lordships can give us a date, maybe 2 weeks or something, because the government has to anyway apply it also.
Okay, because court is also kind of monitoring the, seems like in, so construction, illegal, cancellation, everything is there, so.
Yes, I am against the cancellation.
But that has already been done.
Yes.
And that has been done in terms of observation. No, earlier it was done, then there was a permission for us to run something. Anyway, we'll take any urgency?
No.
If both sides are not having urgency after 2 weeks, as agreed to by the Learned Council for the parties, matter stands adjourned for 2 weeks. Any date you want or to after 2 weeks? Preferably date.
If lordships are giving us a date.
Okay, give a date. After 3 weeks, give a date after 3 weeks.
After 3 weeks, yes.
4th of April 2024. Push the registry to list this matter in the admission column. It is in the admission. No, rule has not yet been issued.
Yes.
List in the admission column.
Great.
Obliged to learn.
Yes, Mazumdar.
Have the
CRP effect. We'll complete by half an hour.
I don't think, for me, it will not take more than 7 to 8 minutes. Yes, they can.
Issue is a
Very-
facts,
very small,
there is no dispute.
Yes, my lord.
Facts, there is no dispute. CRP Act. Facts, there is no dispute. He was,
Only the task, my lord, whether this,
no, only thing is that accident is no dispute. His temporary is not dispute. His under training is not dispute. Now under with such circumstances, whether he is entitled for the benefit under the scheme. That's all.
will have, section 2D,
Section,
2D.
but we'll do it in piecemeal because we are now in a bench 5 from land acquisition to service.
I'll go very, very soon.
So therefore we'll not keep it as a CAB will dictate.
My lord.
Today may not be possible. We'll just conclude the hearing today. And we'll deliver the order some other day. Around this 3:30, you will be free.
I'll be there.
2D.
2D.
member of the
Just
board.
one side question. 2D. CRPF Act, huh? Section 2D. D.
D for Delhi.
D for Delhi. Ma'am,
Member of the force means a person who has been appointed to the force by the command.
Hmm.
So once he is appointed by the commandant, he becomes a member of the force.
Okay.
Note. Now Lordship will have rule 6. I'm sorry, rule
Just a minute. I'll just note it. First is CRPF Act.
rule 2.
Rule on section 2 within bracket D, member of force.
Now rule 5
Rule 5.
at page 13.
New 15.
Rule 5. Rule 5, particular composition of the force.
Yes, composition
of the force.
Force.
Battalion other than signal battalion. So battalion. Rule 5
The forces shall be constituted
as
a
follows.
battalion other than signals
So
battalion.
it was not a signal battalion. We are not required with the same. We are with a battalion.
Okay.
Force shall be considered as follows. Battalion. What will a battalion wear? Lordship will have 5-1B. The last one. Constable 638. So once there is a constable in a battalion,
Constable.
he compromised, and now Lordship will have rule 6.
Just a minute. Now, what is this composition of force A, battalion other than signals battalion? So you are not under, it will come
I was
under.
not, the person concerned was not sent to a signals battalion. He was sent to a battalion.
Battalion.
Therefore, I'm restricted to battalion.
So it will be 1B, rank in the battalion is 1B.
1B last person.
And last one is the constable.
Constable. Lots of people notice.
Now rule 6.
Number is limited, 638. They may increase it. Maybe they'll have 1200 now or 800 now, whatever. But there is a limited number of constables in a battalion which can be kept.
Okay.
Now now rule 6. All officers and men mentioned in rule 5 shall be deemed to be members of the force.
Fiction.
Now deemed. Once he becomes a battalion, he becomes a constable, he is deemed.
Okay.
Rule 26. Training.
Rule 26.
Training. This is what they are terming to be a basic training.
Training. Okay.
Lordship will find what that is the Deputy Inspector General shall issue a manual prescribing the standard of training. The training shall include the following subject: correct wearing of uniform, ceremonial drill, guard mounting, squad, platoon, battalion drill, weapon training including tear, smoke and riot drill, physical training, education and elementary law, intelligence course, general police duty, wireless and motor transport, any other subject which may be considered desirable to be introduced in the force. This is what they call basic training. They send the person for basic training. Now Lordship will have D. The period of training shall be treated as duty for the purpose. D for Delhi again. The period of training shall be treated as duty.
For the purpose of FR 96B1. What is FR?
96B1. And
FR.
A government servant may be treated as on duty during a course of instruction or training in India. A government servant. To lordships, right? 6B1 in the middle.
6B1, 6, rule 9,
9,
then 6,
small b,
6,
6B.
so small b.
small Roman 1.
These books are very difficult to read. Rule
Lordships,
9,
right in the middle of the
1, then 6A, 6 is there is a capital A. Government servant, okay.
A government servant may be treated as on duty
Hmm.
during the course of instruction or training in India. First time just going to the provisions. So now he is a government servant who is on training in India. Now lordships will have 52.
Rule or a
52.
rule.
CRPF will.
Hmm.
All members of the force.
Just a minute,
52,
just a minute.
page 40 down below.
Just 52.
All members of the force on duty
Hmm.
or on duty with the military force shall be entitled to wound injury, family pension or gratuity as laid down in civil service regulation, or this will be important, CCS extraordinary pension rules 1939. Now to bring in the effect of the CCS rules, lordship would like to have 102.
102 rule.
Rule 102.
One zero two. Yes.
The conditions of service of members of the force in respect of matters for which no provision is made in this rule shall be the same as are for the time being applicable to other officers of the government of India corresponding. CCS, my lord, admitted position for suspension, CCS for this, CCS for that, CCS, even for extraordinary pension rules for those people that say to not under training, but even they are under. So here, everything will be under CCS. So CCS extraordinary pension rules, they cannot escape. Firstly, member of the force he is. Secondly, government duty he is. Extraordinary pension rules applies. That my lord closes the case for the respondents that he would not be entitled to anything if he is under training. The training part is not. Now, 2 or 3 judgments my lord, I'll bring to lordship notice. The pleadings lordship will find how they have gone about in their pleadings. Lordship may like to have page 17, 18, and 19.
Of the repetition.
Repetition. First, I will refer to the repetition, then I will come to the. Why this? Oh, I'm sorry, madam. One more aspect I had to show. One more aspect I had to show. That I missed. That I missed.
Yes, Mr. Nath. I think this is the last item. You are waiting for something. We have just adjourned it saying that you are busy in some other group. Okay, we have given a date.
Lordship will find.
Fourth, huh? Huh?
4.
Okay, next week. 4, no.
So the CRPF rules again.
Huh.
Rule 48.
Rules 48.
48. And this was discussed in another case. That is why I'm talking about. Rule 48, page 39. A consolidated allowance not exceeding.
Recruits subsistence.
Recruit, when they call me a recruit, they try to call me a recruit. And this is where it comes. A consolidated allowance not exceeding so may be paid by the enrolling officer to recruit. For recruiter, for each recruit produced for enlistment. Payment is intended to cover the traveling expense. That we will leave aside. But a consolidated allowance is what comes to it. Now, so we will have the repetition. Page 17. 17. Offer of appointment.
Hmm.
Lordship will find that this
E.
person A
Yeah.
post carries a pay scale. It is not an allowance, it is not a substance allowance, it is nothing, it is a pay scale that they have appointed. Now, my lord, their affidavit in opposition, paragraph 3, page 94 of the record.
Admitted.
Page 94. Brief of this.
93. Anyway, 93, 94, okay.
Paragraph 3, brief of the case.
Huh.
The petitioner number so and so now Lordship will send. RTGD, recruit GD. Till the time he was recruit, was enlisted. Now he becomes enlisted as a constable general duty on 11/1/2011. Juxtaposed with the offer of appointment of 10th of July 2010, he now is enlisted on 11/1/2011. Nearly 8 to 9 months later. So the recruit part goes, now he becomes a constable general duty at Group Center CRPF, allotted to 174 battalion. He is allotted to a particular strength in the battalion. He becomes
Just.
Then reading further.
Just a minute.
No.
Yes.
Then, my lord, after his enlistment, if you read it further, after his enlistment as Constable GD, the petitioner was dispatched from Group Center to Recruit Training Center for basic training. So that is under Rule 26. Under Rule 26, she is on government duty. Another interesting factor which my lord was, I noticed, my lord, Lorships may like to have the temporary services rules. It will assume importance, my lord, in this case because it was not pointed out to the
CRPF temporary service.
No, my lord, CCS.
CCS temporary.
CCS temporary services.
CCS rules, that is this.
My lord, CCS rules, Rule 6. Temporary services. Rule पे क्या लिखा है?
Rule?
Rule 6 is under what he was terminated. Earlier it was under 5. Then they
No, this
converted
is
it
not.
by
This
47.
is CCS, CCA. This is not. There is a manual. No, this is pension compulsion. There is a book I have forget. All CCS, I think this is in my chamber. It is in the chamber.
Swami's
No,
compilation, it comes in.
no, this book is in my chamber.
Lordship has 6.
Rule 6,
Lordship, right.
temporary service rule. Rule 6, okay.
Notwithstanding anything contained in Rule 5, the services of a temporary government servant may be terminated at any time without notice. On his being declared, Lordship will find physically unfit for continuance in service by an authority who would have been competent to declare him as permanently incapacitated for service had his appointment been permanent. And one judgment Lordship had held that till I am confirmed or till I am given the permanent status in the CRPF, I remain temporary. So this will apply. Now, unless that medical authority has to be one which can declare me or the permanent person to be, who can declare Lordship.
That will again come under the other act, CCS pension rules.
And that will come, we will go to CCS pension later. Now, first we'll find out the medical authority who can declare me to be permanently incapacitated.
Okay.
Only then, my lord, they could have
Mm.
resorted to Rule 6.
Mm. What happened to that Nayok's case
My lord, Nayak's case, my lord,
that you have referred to just now?
no,
No
that
writ appeal?
no, not that Nayak. That was not the Nayak. Nayak's case is another case, my lord, that I am bringing to the court. This is 102 was not pointed out to lordship. If 102 applies,
Mm.
then CCS pension rules will apply.
Mm.
In that case, my lord, sorry, CCS.
No, that person, he has he was terminated, we upheld that.
My lord, that it should be like that as far as.
What happened to it?
Tulani.
No division. Huh?
It is settled. That part is settled. Another judgment, my lord, where 102 was not pointed out and lordship held that for promotion, CCS will not have.
Hmm.
That case, my lord, I am praying for it to be demanded back for a review. So
Okay.
that part has to be.
Okay.
But the CRPF took a stand that our establishment manual, lordship held that since CCS will not apply because there is no direct application, therefore establishment manual, although it is conflict.
Hmm.
Now, my lord, 102 says that it is applicable.
Hmm.
So therefore it is done.
That was not brought to the.
That was not brought. But this one, it will have now pay.
That's why we wanted to have this kind of a debate, because we cannot pass orders on mayor praying, give me, give that. We cannot give like that. You'll have to establish what is your right.
Here, my lord, what I will try to show is that
Hmm.
the termination being wrong,
Hmm.
he had to continue in search. That is never pointed out. Now, when we go to the DRB event,
Hmm.
the DRB does not do what it is required to.
Now, then if it is under Rule 6,
So now,
now
there
they
has
will
be an
have to
authority.
a medical authority will have to declare,
Who is the
competent medical authority.
Who is
Okay.
the medical authority?
Okay, now which rule we want
For
to?
that, now we will come to the repetition, my lord, that scheme,
Hmm.
4 of 2011,
Okay, scheme.
page 49.
Page 14.
Page 49.
Okay.
This was given by the respondents themselves in the earlier round of litigation, in the first round of litigation.
Page 14, standing order.
Standing order,
Hmm.
4 of 2011.
Hmm.
Now, lordship will find
No, that is date of 27th of July 2011.
11,
Okay.
27 July 2011.
Hmm.
Now, lordship will find that here
Hmm.
at page 55,
Hmm. Hmm.
before recommending final invalidation,
Hmm.
DRB specifically mentioned in the report about the efforts made to important. We will not go into that matter.
Hmm.
Before recommending final invalidation.
Hmm.
So, for a permanent member of the force, unless there is a recommendation by the DRB,
Hmm.
there can be no process of declaring him to be permanently incapacitated, and therefore Rule 6 will not come into play.
Hmm.
In this case, the opinion on which that is the admit in the affidavit that we have referred to an opinion of 10-3. The 10-3 lordship will write opinion to put. Now, lordship will have page 34.
Place 34.
I'm sorry, my lordship will just prior to this, lordship will have page 54 once.
50?
50.
Okay.
Number 5. Department Rehabilitation Board will consist of the following. Lordship friends, at page 50 down below.
Hmm.
The IGP,
Hmm.
AIGP,
Hmm.
1 commandant, 1 chief medical officer senior grade, and 1 chief medical officer or SM. This is the constitution of the DRB, which can declare him to be permanently incapacitated for any service in the. And on the basis of that authority only, the Rule 6 can be invoked by the appointing authority.
Hmm.
Now, admittedly, they have acted upon the
But-
document, which is at page 34.
Yes.
Page 34, lordship will find is the proceeding of medical officer assembled at CH Dhrodakala
by order of the IG director, for the purpose of lordship will kindly find to conduct review medical examination. It was not a DRB. It was not an invalidation board. It was a review at page 34.
Page 34.
Four.
A board of medical
Medical
officers, CH.
What did it constitute, assemble for? To conduct review medical examination. It was not a departmental rehabilitation board. This is fortified by the fact constitution of the board lordship will find it is a chief medical officer, then another chief medical officer, and then we have a medical officer. The DRB given in this scheme, which could have declared this man to be unfit, was never held prior to invocation of Rule 6 of the CCS temporary service.
Okay.
So that termination should have never. Now this man is terminated. He comes before this court. This honorable court says you have 4 of 2011 kindly considered. What is to be considered? Again, lordship will kindly have page 51. How he is to be considered? I will just take 2 more minutes.
Take your seat, Mr. Mehdi. Where is
I'm
that?
writing.
Page 51.
Hmm.
Number 6.
Yes. Number 6.
Number 6.
Hmm.
It has got 2 duties.
Hmm.
The board will subject the person concerned to critical examination with a view to determine his physical or mental capability, aptitude, job requirement, and after assessing capability, health condition of the person.
Therefore, composition is different, not only medical.
So therefore, before you incapacitate him from service,
Because you'll have to not only consider health, physical, mental capacity, aptitude, job requirement.
all this has to be considered.
Hmm.
Number 1, we'll recommend specifically whether he or she can be notice the term rehabilitated.
Hmm.
It is not allowed to function as the duty or do the duty of rehabilitation within the force by assigning jobs mentioned in para 7 as per his physical and mental health condition. So they have to evaluate 2 types of services. 1, what can I do? Number 2, para 7 and 8, whatever is the job given, what are they required to do? Just prior to that, page 50, 6th line from bottom of para 4. Just starts with the word those who are in need of them. Lordship finds. After the sick or injured person has received.
In fact, I have marked it earlier. The medical officer in charge is of the opinion that there are no signs, indication of improvement, and the individual is not fit for normal active duty.
Now, Lord, will notice this. This DRB will come into force when he will not do any normal active duty. If he can do normal active duty, nothing for his board to do. If he cannot do normal activity, only then they will sit and see what else he can do.
But in this case, they say you are not fit to be normal active duty, therefore you cannot be.
But they also say he is able to do normal day-to-day activities. So therefore, his termination itself is wrong. And one final thing Lordship will notice at page 52, 9A.
Page 52.
9A.
Of
Malati repetition. Repetition is answer of page 52.
Page 52.
52. Last page. The DRB will also recommend, following in their final decision, the personnel under category A of para 2 will be retained in service till they remain in medical category shape 4 as per shape factor mentioned in SO 4 of 2008. Such person may be extended proper medical facility to
improve their medical
category. Now,
In case no improvement has been found and become totally unfit to perform any kind of duty as per medical categorization of SAFE 5 mentioned in 4 of 2008 or any other order issued time to time, they will be recommended for boarding out. So first thing to do is, even if those 3 doctors had sat down, they should have said he's SAFE 5. This SAFE 5, I have got the document. SAFE 5 is a condition where the man is not fit to do anything. SAFE 4 is where he is under medical treatment and in the hospital. SAFE 3 is when he cannot do high altitude, camp duty, running around, holding fire. When he can't do those things, he's SAFE 3. So this man never reached SAFE. It's an out and out matter, my case, where they have not applied their mind is what I'm trying to say. Now, this case will fall. In that case, on page 29, Lordship will find. I'm sorry, not page 29. This will come under page 20. 20 or maybe page 19 also. 19. A. 19. The clause is 22.2.
Just a moment. Give it on 27th, 28th. Release this matter for further hearing on 28th of March. No, you continue. I'm just releasing. Yes.
Now at the
28.
page 19.
20.
28. I will ask the deputy SC to say that don't give any case to Mr. Medhik in Guwahati and put him in somewhere else.
This facility is also there.
Huh?
This facility is also there. in the Canada.
26 or 2nd of April.
Huh?
2nd of April.
No, 22nd
22nd of March.
March. 22nd March. Then we can complete and come back on 27th. There is holidays. 24, 5, 6, 7. Okay, 22nd. Before that vacation.
My lord, what happened? In very bad case, my lord, I've sent to the other pens. My lord, this is my architect. My lord, this is the problem, my lord.
Now we'll take a judicial notice. Whenever Mr. Medhi comes, we'll not hear any argument. This is a bad case.
Because I'm facing this is lot of trouble in every case.
Okay.
Page 19, madam. What they call the appendix.
Yes, 19.
This one may not refer to the judgment, madam, in judgment, but I'm just trying to give a picture of what kind of a people they say are incapacitated. This appendage, madam, it means the hand and the foot and the fingers. Numerical grading, Lordship has the table. A1, full functional capacity. Lordship will find A1U. U means upper. So if the upper part of the body is bad, loss or disability of terminal phalanx or anyone of the so-and-so, he will still remain fit for all duties. Lordship finds. It's 2. So even with loss of fingers, he will remain fit. Loss of terminal phalanges, fit. A1, loss of terminal phalanges, fit for duties anywhere except operational IS duties or during hostility he cannot do. The last one, Lordship will see on the table on the same page, has a defect or disability of the moderate nature of one limb below the knee. Even he stays at A2. It is only A3. He becomes not fit for operational counterinsurgency duties, can do IS duties without crimes. IS is the internal security, trying to get some information as to what is happening inside the campus. Area restriction is not applicable. Then fit for sedentary duties also. It is A3 only. So therefore I say, even at A3 you cannot send them in. Then comes A4 Sikkim Hospital, and it is thereafter A5 that he becomes permanently unfit for any sort of leave. Two legs gone, two hands gone. They go. Even this standing order 4 of 2011, they require a man to become shape 5 plus. Prior to that, it cannot be done. Now, another compassionate thing that standing order 4 of 2011 at page 53 does is, again page 53 my order refers, that they cannot take away they cannot give up their responsibility like that. Page 53.
This clause.
B.
Hmm?
Clause B.
Hmm.
Personnel who have less than 10 years qualifying service at the time of invalidation and their disability is attributable to government duty will be entitled to disability pension as per existing instruction. Now, Lordship will see C. Personnel under category B will be retained in service up to 10 years of service to make them eligible for invalidation pension. The force, the idea of the force was never to send out such people. Give them something and send them. Is what they.
That was what was
Is that
in our mind. Can you throw up people like this? That's why we dig into this.
everything is a
That's why we dig.
I understand.
now.
Otherwise, your stand was that he has come injured. You are in training. Go home.
Yes.
We don't have any. That cannot be.
I understand.
And in a society or in a country where it's rule of law is holding the field, this is the rule of law.
No.
That has been prescribed by the government. That can be wrong interpretation by an officer. That is a different thing.
Yes.
But state cannot do this. Therefore they have prescribed this.
And in the Assam Rifle, it is different. In Assam Rifle, this recruit word carries on till he completes the training. Therefore, for them, they send.
Therefore, whatever is.
CRPF is a paramilitary force. Assam Rifle, it is administered by the army. There, the situation is a little different. Now, one judgment that I will refer to for lots of convenience. This is a judgment of the Delhi High Court.
Give one or two which is the most fitting. Not too much of judgment.
This is Pradeep.
Pradeep.
Nandajog and Suresh. This is appellant is Walesh Ahmed. Decided in 2011. Lordship will find at paragraph 8 of the next. What had happened is, I'll give it just a short bit. This man was traveling during training in a CRPF bus to go and apply somewhere else also. Bus met an accident, person died later on of injuries. Right. A recruit is a person who does not receive any salary but is given a stipend for the period he remains in training.
Any recruit is defined in anywhere?
Recruit word is not defined. Enlisted word is defined.
Where is that?
Enlisted is section 5.
Section
enrollment is 5.
Enrollment.
Section 5.
Section 5.
This is enrollment.
Okay, so recruit we can go to the dictionary meaning, but or you can take up this definition given. Recruit is a person who does not receive any salary, but is given a stipend for the period he remains in training.
That is what a recruit is. It has been held by the court matter, by division bench of the court matter. Therefore, and here, my lord, what the honorable court has done is, when the person died, they went to the MSCT Act provisions, saying that he was a person serving in the force, traveling in a government vehicle, entitled to compensation 10 lakhs. Other than what was given by the MSCT, but another 10 lakhs was given by this. Then, my lord, one judgment, my lord, others they've already placed. One judgment by Justice as he was then.
You have already placed some judgment, no?
I have not.
Okay.
Training is government duty. This judgment.
Okay, which paragraph?
Para 10.
Just a minute.
Here it was a conferring the promotional benefit. We will take it for the purposes SO4 of 2011. Having noticed the rival submission, let us now examine the purport of beneficial circular dated 27/7/2001. If the circular is interpreted to mean that only for injuries suffered in course of war or fighting insurgency would entitle a personnel for promotion despite low medical categorization, the situation contemplated under subclause B would be redundant as the situation referred in subclause B of clause 13 are not akin to active battle or involvement in active fighting surgeons. They relate to cases where injury is suffered through accidental situations and there is no reservation for such accidents to be in the battlefield or in the course of active fighting or counterinsurgency or border operation. Therefore, considering the fact that the circular is meant to confer promotional benefits to personnel suffering certain degree of medical disability, it must be given a liberal interpretation. Look at thus, I feel that it should be logical to understand that the subclause is intended to give benefits to personnel who might be injured in training and non-combat situations. We just turn back to the standing order, my lord. In the standing order at page 49, A, those who are disabled due to
Injuries sustained in action against terrorists, anti-social elements, insurgents, Naxalites, while undergoing training.
Internal security undergoing training. Or otherwise also, if we bring him to clause B at the next page, if we term it to be an
Those who are
accident during
disabled
training,
due to sickness or accident.
accident training, accident. If he comes under B, then my lord, the duty to retain him till he completes 10 years of service to get invalidation pension. That will come. So one, my lord, apparently, I do not think that the termination was correct. Two, they
Now,
did not
what relief he can
silence.
be granted? Assuming for a moment that we accept your argument.
The first,
Subject to what Mr. Mehdi says, what should be your concluding remark on the relief that can be granted?
the termination apparently being wrong.
Mm.
But it is not a case where he cannot be terminated. He can still be terminated. But before that, the DRB has
So your case is that procedure required is not being
certain
followed.
law to be followed. That is Rajpal Singh again will come in India versus Rajpal Supreme Court case active. When a procedure for medical invalidation is given, word to word it has to be followed. There can be no change in procedure. Therefore, first the DRB shape 5 has to come before that. DRB will see for every dark runner this there what is each capacity they will see. Totally unfit they will give it. Then rule 6 will come into play. Before that, DRB has to give him 10 years so that he can get invalid. And as far as CS extraordinary pension rules, that the nature of the injury, that is also given in certain tables, my lord. Page 9. From page 900 and around 900.
That pension rules, extraordinary.
Extraordinary pension rules. Many sorts of injuries are given, and injury during training has been taken to be injury during government duty or attributable to government. So that will again come. That the doctors will decide whether it is 40%, 50%, and give him that invalidation pension if he has to go. And otherwise, he has to be adjusted. But simply go home
will not.
So it is, unless he is first found to be, the shape has to be determined. As per the shape, the DRB has to recommend. Only if he becomes shape 5, still he gets 10 years of service and then an invalidation. Prior to that doesn't go. Otherwise, a young boy of 18 years, he comes, he joins, he loses his leg.
That was
They will
our
send him home
that
today.
was our worry. That's
will
why
send
we wanted to see that can the law be like this?
Not only the loss of income, lordship will also appreciate. He loses a leg. He cannot apply anywhere else again. But if we go by standing order 4, he will stay for 10 years, get an invalidation pension. He'll live on the pension. That has been provided.
Yes, maybe 20 seconds. You have understood what is argued. Now you reply.
Only in this, my reply will be the difference between the basic training and undergraduate training.
That is.
He can bring on record the DIGP's order on basic training. What consists basic training?
Yes,
If it is exactly what is
because there is also the rule 9, this oath. Oath is there. After completion of basic training, there is oath is there. So oath after oath, there is another provision. He is being listed in a property commandant. There is seat. Then his name will be included here, and that I have to explain before it's not. This only this our and that is this, these are
because so far this, I'm.
Okay, on next.
Only one line. So far those visible injury, this last one is, my lord, this, earlier, my lord, the insurance and oculist, last is undergoing. Because if it is, into the basic training, it should be in first,
Heard in part. Okay, I have already dictated the order, 22nd. Give a pin, give a pin.
only my friend will, I'll take this. What is submitted, my lord. Hello.
Keep these books, huh? On next date, we'll dictate, we'll tentatively take around this time.
Yes, yes, yes. Yes.
We'll finish the list,
Yes.
then we'll take up.
Then it is better because after.
So that's why, because, and this bench is also two different things are now happening. Na?
And one case, my lord, is, I argued, my lord, one ED case, my lord. And it was ultimately in our favor. Some observation was there. But ultimately, last date, my lord, I was not in ED, my lord. So this.
What happened to that? That is ended or it went to
I
after?
am not in ED now, so my lord.
So for
That
today,
is good, as I forget.